We
All
will
well,
commence
well,
the
well.
second day. We will commence second day shortly. Vikram સાહેબ આવે એટલે.
Yeah, sure, sure.
ને શનાઝમેન ફર્સ્ટ ડે ઇઝ ઓવર તો એટલું શાંતિ લાગે છે ને સેકન્ડ તો ઇટ ઇઝ ઓલ ફેમિલી ફોર મી ઓલ આર
Correct, correct, correct. Right. But you have worked very hard and you have put a lot of effort in it. Your personal effort in it.
Yeah, that's
તમારા બધાના સપોર્ટ વગર કંઈ નહીં.
Salute to you.
And I salute to all of us. Without the support, not possible, not possible. I'll just call Vikram sir and rejoin.
Yes,
Just
yes,
give me
yes,
1 minute.
yes, yes.
Sir has joined, Vikram sir. Good morning, sir.
Good morning. Good morning. So you well
Welcome.
arranged the seminar. You have well arranged the seminar.
You તમારી પાસે જ શીખ્યા છે સાહેબ.
No, you have given opportunities to all the participants to sufficiently represent their views.
We have learned from our seniors. Right, Shanaz madam? ચાલો.
Absolutely right. Pailagu, Vikram sir.
Oh, thank Suprabhat.
ચાલો. Anisha madam, can we start? Vikram sir, Manisha ma'am, Shanaz ma'am, Harshad bhai has joined us.
yes. Good morning, sir.
Good morning.
Okay.
Anisha madam, can we start?
Yes, ma'am.
Okay, fine.
A very good morning, ladies, gentlemen, colleagues, and students. I, Anisha Sahwala, welcome you once again to the day 2 of the second virtual 2-day national conference on expanding horizons of consumer rights. It is a special privilege and honor for me to welcome you all on behalf of BT Choksi Sarvajanik Law College. I request the conference chair, Dr. Irmala Dayal Madam, in charge principal of BT Choksi Sarvajanik Law College, to give brief remarks in this distinguished virtual gathering. Over to you, ma'am.
Thank you, Anisha madam. A warm welcome to dignitaries who are gracing this second day of our national virtual conference. Before we proceed, I'll just make a brief announcement that we will be announcing 2 best papers today, one from the teachers category and one best paper from the students category. All the session chairs have submitted their evaluated sheets and few are going to submit soon. So on basis of the marking, we will be announcing. And before we proceed further, શનાઝબેન તમારા સેશન શેરમાં 5 પેપર્સ આપણે વાઇવ ઓફ કરી દીધા છે. એટલે there will be only 9 papers which are going to be presented. Last minute પર પછી આપણે બહુ પ્રેશર નતું એટલે આપણે કીધું next time. Okay, so only 9 are going to be. Vikram sir, a warm welcome, and Anisha ma'am, we can move forward.
Now, we shall begin the learning session, for which I would like to call Nikun sir for further introduction.
Fine, good morning. Thank you, ma'am. I now welcome Dr. Vikram Desai, sir. He is a former Dean Fine. His expertise in constitution has won him several accolades. He is a taskmaster who brings out the best in students and at the same time is just and fair. He clearly is an asset to the law academia. We are honored that you are part of this distinguished virtual conference. Over to you, sir.
Thank you. Good morning to all
Sir.
those who have been joining this learning session and those who have presented their papers. More particularly, Irmala Ben, who has very nicely arranged this seminar on a very important issue or a very important subject on the awareness of the consumer law, which is also one part of the syllabus, one part of the chapter section in the Consumer Protection Act itself. Shehnaaz Ben, Manisha Ben, Nikita Ben, if she has joined, Hina Ben, Monica Ben, Twinkle, and many other teachers who have joined in this learning session. First, I would like to say something about the development of this law, Consumer Protection Act. In this learning session, I heard some of the participants who has dealt at length on the various facets of the Consumer CPA Act, and they have also tried to explain themselves how the Act was widened in 2019 and again in 2020. Shehnaaz has talked something on e-commerce. The other participants has also defined commercial advertisement and the definition of consumer, etc. I am not going into detail of this. I am just, as my usual habit, I always first talk about the jurisprudential basis of all the sections that has been incorporated in the CPA Act and how the law has developed, from where it has come, how it is to be interpreted, and what are the important judgments that has declared that the law on some particular aspect is final now. So therefore, one has to go back to the pre-Consumer Protection Act before 1986. Which legal mechanism was there to protect the rights of the consumers? Now, the word consumer was never there in the legal dictionary before 1986. The word is a buyer, and the principle was buyer beware in Sale of Goods Act 1930, a British model law which we have adopted. Certain rights have been given to buyer. They were given an exceptions to the rule of contract, and the provisions under the Sale of Goods Act stands on the doctrine buyers beware, caveat emptor. And the whole market was established before 1986, taking as a basic principles of this. Therefore, whoever buys or sells goods, they live at their mercy, even if the goods were defective one, or the goods that he have received by way of negligence. He can have no forum to say anything. He can't file any complaint. He can't go to the civil court. The only way open for himself was law of tort. And in law of tort, tort law, as Bakshi Sahib used to told us, tough law. Tort law is a tough law. Several principles were there where you can go to the civil court and file a civil suit for recovering the damages for the negligence caused because of the purchasing of the goods, defective goods. I was also a lawyer and I also filed 2 suits before the electricity board, but I managed to get the decree after 10 years, that too from the High Court, because of the strict construction of the definition negligence. Certain principles of this negligence were thereafter incorporated in the Motor Vehicle Act. So any person who dies in an accident or met with an accident, dies or receive any injuries, he can move to the Motor Vehicle Tribunal, like Consumer Tribunal, and he can recover compensation from the insurance company, third-party insurance company, by filing a motor vehicle petition. So far as the Consumer Protection Act was concerned, we must understand at that time that it was a closed market, not open like this, which was open in 1991 under the liberalization process. So market was very close. The legal mechanism was poorly adequate. And therefore, at the international fora, a hue and cry was raised about the protection of the rights of the consumers. After all, it is the consumer who is running the market. Shehnaaz has started her paper by saying that consumer is a god, but consumer was never treated as a god. Consumer was also at the mercy of seller or the person who is providing the services. Even there is a crass negligence by the doctors. In one of the cases that I have confronted, he had amputed the left arm instead of right. It was very difficult to get compensation from the said person, even though we move up to the Supreme Court. So therefore, you must understand, friends, that the tort law was the product of the law of obligation, and the consumer is also part of the law of the obligation. From there, it's derived in its genesis. That was the jurisprudential basis of the Consumer Protection Act. And therefore, the several decisions that has been rendered right from 1986 to the last one is that of the Regional Provident Fund Commissioner. That was kept in mind the historical aspect and the development of law on the basis of the history and the principles of jurisprudence working in it and incorporated therein. The court has now tried to interpret, started interpreting several provisions of the law in that direction. Now, friends, when I read the law of 1986, 2 very significant things were incorporated. And in my homework, I have found that from 1986 to 2019, in several decisions, the court has not interfered into the large definition of consumer that has been there in the 1986 Act, Section 2D. The word buyer has not been there. The word consumer has been put into it. And the consumer means the person who is consuming the services, buying the goods, except that who is purchasing for the commercial purposes or for his personal employment, except that everybody was treated as a consumer. But there was two words that has been put before the definition. And I request all of you teachers to read carefully the words that has been used in every section, which follows which. That is very much necessary to understand the basics of the law. And that law, that the words are hire or avails the services. Now, no doctor has put the board that you come here and we will examine your body and in this money and that. Such a type of advertisement was barred for the professionals, for lawyers. You can't have a advertisement board of a lawyer said, I'm a specialist in murder trial, I'm a specialist in matrimonial trials. You can't go through such kind of advertisements. So therefore, you are not going to buy his services, you are going to avail his services. You are hiring his services for the purpose of consideration, by giving consideration. This branch was left out from the purview of the applicability of the Sale of Goods Act and the Contract Act and the tort law. Therefore, we were defenseless before 1986 to where we go, to where we file a complaint or a suit. 1986 law made it very much clear that consumers is a comprehensive, inclusive definition. And in its inclusiveness, it covers all those, not only buying and selling the goods, but all those who are hiring and availing the services. Only rider is that the services or hiring or the availing of the services is for after paying the consideration. And therefore the civil hospital was barred from the purview of the Consumer Protection Act, or those doctors who are giving you family doctors who are been left out of the purview. But friends, now hiring and availing the services, and these two words have been very comprehensively interpreted in the Medical Council case later in 1988. Because the argument was advanced that nobody has requested them patients to come and take the services of the doctors, and that the doctor is relying upon his knowledge of the medicine. He administered the degrees, he administered the medicine, and the person died or he met with a fatal accident, and therefore the doctors are not coming within the purview of committing the negligence. But that view was not accepted neither by the National Council nor by the Supreme Court even. But on that aspect, I will come later on. But when I have seen that 2016 Act was successfully covering all the aspects of the harm and negligence and the things and the damages and the territorial jurisdiction, etc., etc., 5 major points require amendment, and that has been fulfilled by 2019 Act. 2019 Act repealed 1986 Act. Now 5 major changes have been made in 2019 Act. That was very much necessary. And that 5 significant changes were: number 1, the sections were added at 247, 246, 228, etc., etc. The definitions of unfair trade practices were added. The definition of unfair contract was incorporated. The definition of misleading advertisement was also there in 228, section 228. And the territorial jurisdiction, which was a very major roadblock in filing complaints under the Consumer Protection Act after e-commerce came into force, that difficulty was removed by 2020 Act. As you know, the 2 other changes were made were introduction of CCPA, that is Central Consumer Protection Authority, and the fifth one is sending the complaints to for mediation. So mediation clause was also incorporated in the new act. And the main important are the rules regarding e-commerce in 2020. That was the significant amendment has been made by the government. Earlier, if any person is buying or selling the goods by e-commerce online, the complaints were dismissed on the ground of territorial jurisdiction. Suppose a person is living in Surat and he ordered the goods online from Bombay, and when it was a defective one, either is it a Surat court or a Bombay court which have a jurisdiction to entertain the complaint, the law was not clear on that matter. And it was continued till 2019. Unfair trade practice, unfair contract, misleading advertisements are very important things, because advertisement controls the whole things, whole market in our country. And every day we are hearing so many advertisements tend to mislead the person to buy that goods. And ultimately we found that it is not the goods it is not the goods which was made for the purpose for which it has been made. So therefore, the three things which have been very extensively referred into the new act is unfair trade practice, unfair contract, and misleading advertisement. Those who have presented the papers have very nicely covered all those things. Therefore, I am not going in detail of this. But the question of territorial jurisdiction, which was very much important before 2019, when the act was amended, two provisions were made in the new act, and that is of the e-filing of the complaint. Now the person can also file complaint to collector also and district council also. And therefore, anywhere where he resides or works in the district, the consumer can file a complaint. And another important amendment was carried out was, for the first time, like company law, a punishment clause was also incorporated by section 21(4) of the act, where if there is a misleading or false advertisement, the punishment is up to 6 months, there is imprisonment up to 6 or 10 lakhs fine. So these are the important developments that has been carried out in the CCPA Act, Consumer Protection Act, CPA Act in 2019 and 2020, by providing with this e-commerce rules, etc., etc. Friends, now the law has tried to cover up all those defects which have been laid down in 1986 Act. One thing that was still missing, according to me, this is my academic view, is that there was a suggestion that those who are coming for advertisement like Amitabh Bachchan or any hero or heroine or any doctor, and if he says that the particular things are useful for this, and if it is not found that it is, and ultimately it is found that it is not proper for that purpose, he should also be made liable for this. The person who has been hired for this advertisement, the hero, heroines, or any person, he should also be personally made liable for this. But that clause was removed, and it has not been there, not found in this act. So they can stop the advertising, falsely advertising the same things by their name. So therefore, personal liability of those persons who are coming for advertisements also required to be fixed. That was the suggestion. But ultimately that clause was dropped. But anyway, some of the significant changes that has been made, which I have, and that was the constitution of CCPA is very much important. It's like a SEBI. Because after all, the question of delay was not addressed in the new act. there are still delay. You can't get a order from the district council even after 1, 2, 3 years. There was a considerable delay. It is because of the lots of filing of the cases. Secondly, those who are going to court, they have to suffer a lot, even though the entry of the lawyers was not permitted. It is good that the jurisdiction, pecuniary jurisdiction, have been widened, and that has been now made up to the district and state councils were now been extensively their power was widened up to 10 crore to state council and more to the central council. Look into the other significant character of the CPA Act was the jurisdiction of the High Court was also barred. A person cannot go to the High Court only if he proves that there is a violation of his fundamental right because of this act. Otherwise, the order from the Central Council will only appealable to the Supreme Court and not to the High Court. That was a great thing that made in any legislation so far as these type of legislations are concerned, which are have their genesis in the law of obligation. So, my friends, these are the things which are there in the Act. Now, some of the decisions that have been rendered recently that was, and that proves itself that how the court is taking seriously about the implication and interpretation of this law. When I have read the judgment of the Medical Council, there were two conflicting judgments of the Andhra Pradesh High Court also. And one of the judgment was that a person who is rendering Ayurvedic or Unani or homeopathic services and some negligence caused to him, whether he will be brought within the purview of this act or not. And the Supreme Court said that they cannot practice like this and they are also coming within the purview of this act, even though they are not giving any basic drugs. And secondly is that the Regional Provident Fund Commissioner, if he is not released his pension Provident Fund orders, he was also covered within the definition of this. He was also fall within the definition of this Consumer Protection Act. So far as the question of giving services without consideration, the court has said that the in civil hospital case, I forget the name of that case, most probably it may be the Vasant Nair's case, that the activity providing medical assistance by the civil hospitals without consideration, and argument was also made that the consideration was indirectly paid by way of salary by the consumers or by the patients, and therefore they should also be covered within the definition of the this act. But Supreme Court has not has dismissed those arguments and said that no, it was a free services, and therefore the free services without consideration is not coming within the purview of the this act. So, friends, what the points that I would like to explain to you is this: that any act that is now it is a 40 years act almost, and we have enough now the mechanism or enough forum that has been prescribed by a particular legislation, specific legislation, to deal all the issues about the rights of the consumers. And therefore, when any rights of the consumers are violated by way of negligence, by way of deficiency in services, or whatever it may be, they are required to be addressed by a competent authority, and that has to be implemented correctly by the competitive authority without going into the too much technicalities of the law. When some matters were argued in the court on too much technicalities, it was not like a penal law. A penal law was interpreted differently, a constitutional law was interpreted differently, but law of tort should not require any technical interpretation of law, because if you go to technical interpretation of law, it violates the very object of the law. And that is not permitted by that is not permissible. Therefore, when you see, when section 125 of the CRPC was interpreted by the criminal courts, they are saying that you have to pay the maintenance with no argument is necessary to go away from this liability. Similar is the judicial process so far as the interpretation of the Consumer Protection Act is concerned. Too much technicalities. Court is not entertaining. Out of 10 cases, you hardly found any one cases wherein the court dismisses the complaint of the consumer. Once it is found that there has been existence, of a negligency, and that the negligency has correlated effect of causing severe damages to the consumer, and that is sufficient to establish the case without having any formal rule of evidence. This is how the act is working at present. So in Malabina, I think I have taken enough time to express my views on the very important branch of law, and I think it must be useful to you. I now switch head over to you for further proceedings of the seminar. Thank you very much.
Sir, thank you for your speech. મારી query તમારે એ છે કે endorsers due diligence practice કરે તો they are not liable. Now if it is not proved in the court કે advertise કરવા વાળા endorsers due diligence નથી exercise કરતો, can they be tried? I'm thinking about that.
That was incorporated by the section 32. I have mentioned the section new punishment section was incorporated 21(4). Misleading advertisement.
સારું.
Hello.
હા.
Misleading advertisement. Now the fine up to
મને
₹10 lakh.
Okay.
Fine and imprisonment for 6 months now.
Judicial interpretation થશે ત્યારે જ વધારે clarity મળશે મને એવું.
No. Actually,
thanks
those
a lot.
persons who are giving advertisement were left out. Only the companies were now made liable. Amitabh Bachchan
હું એ જ
and
કહું
other
છું કે
people.
જે endorser
No, but that has to be left out. I have mentioned this in my lecture. But otherwise, the demand was that they must also be held personally liable. Whoever giving such advertisement. Yes. Yes.
Anisha ma'am, we can continue.
Thank you, ma'am. Thank you, sir, for such a wonderful learning session. I would now invite Advocate Sri Kamlesh Patel, sir, for expert talk. Sir is mainly practicing advocate on civil side since 1979.
મેડમ સર 2 મિનિટમાં જોઈન કરે છે ત્યારે આપણે એમનું ઇન્ટ્રોડક્શન કરીએ. ત્યાં સુધી આપણે વિક્રમ
So,
સર સાથે
ma'am, we
ચર્ચા
can wait.
કરીએ. શનાઝબેન
Oh,
તમારી
you.
કોઈ query?
Any query? You can put any query to this.
Okay, ma'am.
He's joining in 1 minute. 1 મિનિટમાં વિક્રમ સર ને કમલેશ સર છે તો કે હું આવું છું. વિક્રમ સર ને વેલકમ કરી લઉં.
Yes, I am there, madam.
And I hope JT sir has joined. Has he joined? Kamlesh sir is here. Good morning and a warm welcome, sir.
Yes, I am here.
Anisha ma'am, kindly take over.
Good morning.
Sir, એક જ મિનિટ. Good morning.
Good morning,
Anisha
ma'am.
તમને just 2 minutes, sir. Good morning.
Okay.
Yes, ma'am.
Introduce.
Good morning, Kamlesh sir. Namaskar.
जरा अंदर आओ.
Anisha ma'am, introduce.
चालू करने निकली क्या बोलो.
Anisha ma'am.
Panel advocate. Yes, ma'am. Ma'am, am I audible?
Please begin.
Yes, ma'am. I would like to invite Advocate Sri Kamlesh Patel, sir, for expert talk. Sir is mainly practicing on civil side since 1979. He is also visiting faculty at VT Choksi Sarvajanik Law College and also a good academician. He is also a panel advocate at many banks. Sir, it's over to you.
Thank you very much. And good morning to you all. Too many things have been.
Good morning, sir.
Good morning. Too many things have been explained for me. I don't know whether I am possessing that quality or not. But still, however, it can be said that I am a senior lawyer. And so far as my introduction of today's lecture is concerned, that I am a lawyer. Because I am now retired everywhere. Still, however, I used to go to the college because of it is my passion. Anyway, I am really very much thankful to the college administration for inviting me for this, and I'm really very much. I'm sorry for I could not join on the last session of that is on Friday. I think it is on Saturday because of my other commitments. Well, friends, till date, you have come across a number of lectures. First of all, Irmala Madam might have give the introductory speech. Thereafter, Justice Mahendra Parikh, Justice Vishnu Kumar Patel, then Shukar Pastonji, the senior lawyer of the Supreme Court, the Shreyas Desai, the leading advocate so far as the consumer protection is concerned in the entire South Gujarat region. These people must have explained the importance of the law, the necessity of the law, and under which circumstances were required to be enacted. What was the situation prior to this enactment? This enactment came into force in 1996, and last amendment took place in this particular act is of 2019. Till date, how the law has been proceeded, how the law has been interpreted, what were the problems the litigant has faced, and how all the problems were overcome by the authority concerned, and how the law has been, and how the people have got the justice, and everything should be. The people must have explained all these things to you. You all are fully loaded by the latest knowledge and latest law of the Consumer Protection Act. And today, in early morning, my very close friend Mr. Vikram Desai had also enlightened you on a very important aspect so far as the Consumer Protection Act is concerned. Dear friends, I am not here to deliver any lecture so far as this particular subject is concerned, because I will have to the court at 10:45. But I just want to see you all, I just want to meet you all, I just want to convey my good wishes to this particular webinar which has been organized by the VT Choksi Sarvajanik Law College. The painstaking efforts have been made by Madam Principal Irmala Ben and her team. I must congratulate to them, and I am requesting all of you that what you have gathered from this webinar on day before yesterday and from today you are going to gather, from today the information you are going to collect will be definitely going to help you in enhancing your knowledge regarding the Consumer Protection Act. The persons, those who are interested in practicing the Consumer Protection Act, I must say, it's a very good field to practice there. Because at the cost of the abuses of my friend Shreyas Desai, I must say that Shreyas Desai is the only person in Surat area who is taking care of all these type of matters. Friends, it's a very interesting subject. The practice is also very much interesting. The redressal so far as your complaint is concerned is also very effective and speedy in comparison to any of the civil disputes. Ultimately, the dispute falls on the law of torts, and as Vikram Bhai has rightly told, that in law of tort, you cannot interpret the law as you are interpreting the other laws. Under all these circumstances, without taking much more time of your, I will convey my best wishes to you all, and I hope that in future also these type of webinars on different subjects may be organized by the college, and if at all these type of webinars are arranged by the college, and if I am available, I will be definitely going to join, and I am definitely deliver any lecture on it. Thank you very much for giving me this time.
Thank you, Kamlesh bhai. Kamlesh bhai, how are you?
Yes, fine, thank you, sir. Fine. I am here to see all my old friends.
Yes.
They all have worked with me for a very years together. Venus Ben, Manisha Ben, Dr. J.T. Desai, Dr. Vikram Desai, Dr. Irmala Dayal, they all are my old colleagues.
Yes, sir.
And I enjoy my entire era.
Yes, because of the webinar we met.
I was a dean and I didn't feel any tension when I was a dean, because all of my friends were there to share all the responsibilities in the interest of the students at large.
Right, we were de facto deans.
ઓકે સર સી યુ હિરવાલાબેન હવે બીજા જે સ્પીકર હોય તેને આગળ આપો.
Okay, okay, okay.
Thank you,
Okay,
sir.
okay.
Thank you very much.
We agree.
God bless you, sir.
Thank you, sir. તમારા આટલા વ્યસ્ત.
Thank you.
Thank you, કમલેશ sir.
Thank you.
આટલા
Thank
વ્યસ્ત
you.
શેડ્યુલમાં બી ટાઈમ આપવા એની
હું
માટે thank
કહેવાનું
you.
નહીં હોય નહીં તો આવવાનું બંધ કરી દઈશું. આ તો 5 જ મિનિટમાં અહીંયા નીકળી ગયા. અહીંયાથી ઓફિસ તમારી કોલેજ નથી આવવાનું. એ મારો આખો આવવાનો ટાઈમ અહીંયા જ પૂરો થઈ
એવું
ગયો.
ના
હું સારી
કરતા.
રીતે
તમારા
તમને
સપોર્ટ
જવાબ-
વગર કઈ નહીં થશે.
હા. Anyway, I take leave of all. Thank you very much. Thank you.
Thank you, sir.
જનકભાઈ
JT sir has joined. JT sir has joined. Anisha ma'am. Just a minute, I'll call him.
Hello.
હા, JT sir હમણાં 2 મિનિટમાં જોઈન કરે છે.
JD sir has joined. Thank you, sir, for your stimulating learning sessions. I now request while Dr. JD Desai, sir. Dr. JD Desai, sir, is the former Dean of the Law Faculty, VNSU. He has written and published several books and research papers on law, and under his guidance, many students have received their doctorate degrees. He has participated as an advocate for 10 years and having 35 years of experience as a legal educator. He has also served as the principal of Valsad Law College and chairman of Legal Education Branch. He is also associated with the various other universities like GNLU, NIRMA, Oro, Parur, etc. His expertise in research methodology has won him several accolades like Shiksha Ratna Award and many more. We are honored that you are part of the distinguished virtual conference. Over to you, JT sir.
Hello, am I audible?
Yes,
Good
sir.
evening,
Yes, sir. You are completely audible.
Okay. Good morning, all of you. I feel
Morning,
immense
sir.
pleasure.
Good morning, sir.
I feel immense pleasure for getting an opportunity of sharing my views in this learning session. First of all, I'd like to appreciate the words learning session used by the host. I think all of us should remain learners up to our last breath. First of all, I'd like to differentiate the approaches of laymen and law scholars regarding the learning laws. So far as laymen are concerned, elementary knowledge is enough for them. Just they should have the information about their rights, their procedures, and remedies available to them. But so far as the law persons or law scholars are concerned, they have to pass to the historical approach. They should adopt historical approach, analytical approach, comparative approach, doctrinal and non-doctrinal approach, innovative approach, utility-based approach. These are the expectations from the scholars of law. The law persons or the law scholars has to start with the identification of the problem, then historical study, brief history, then relevant policy, enactment, principal legislation, subordinate legislations, rules, regulations, then interpretation, case laws, latest update, and uh, suggestions. These are the expectations. Just we are supposed to find out the difference, what is on paper and what is the reality, and whether the objectives of the particular act are fulfilled or not. That is the basic function of a law scholar to see. So, first of all, I would like to start with the brief history of the consumer protection. First of all, we'll see what is the situation at global level. So at global level, we can see the root of this consumer protection even in the Code of Hammurabi, but it was only in a mercantile perspective. And up to the 18th century, there was only a concept of buyers beware. Now it is shifted to sellers beware. Consumer organizations were established for the first time in Denmark in 1947. Then in 1955, Great Britain's government created consumer councils. Early forms of movement began in the United States. In 1962, former President John F. Kennedy declared 4 basic consumers' rights. And all of you know that 15th March is declared as World Consumer Day. Now, let us talk about the situation or the development in India. The origin can be traced out in the text of Manusmriti and other religious texts. But prior to the special enactment of 1986, the rights were protected through scattered laws, through different laws, like in the era of common law, law of torts, Civil Procedure Code, Indian Constitution, Contract Act, Essential Commodities Act, some provisions of Indian Penal Code, Food Administration Act, etc. But as all of you know, that the landmark step of enactment of special legislation was taken in 1986. This is the landmark step by our Indian legislature. As per the statement of objects and reasons, it was enacted for better protection of interest of consumers. Consumers' interests were protected prior to that act, but the procedure was lengthy and remedy was available in civil court and criminal courts only. So, the special enactment, through the special enactment, rights of consumer was identified. This was the first significant point. And thereafter, advisory authorities like councils were established, dispute redressal authorities were established, procedural and remedial provisions were included, and rule-making powers were given to governments. Thus, it was a short and sweet enactment having only 31 sections. But after 1990, we know that the era of LPG, liberalization, privatization, and globalization started, and we passed to the era of ICT, information, communication, and technology. And subsequently, e-commerce started. Obviously, coin has two sides. Online marketing saves time and protect consumers from some inconvenience, but simultaneously, it doesn't provide an opportunity of inspection of goods, and therefore, instances of online fraud increase day by day, and therefore, there was an urgent need of speedy and easier mechanism of redressal for the same. Ultimately, after a lapse of long time, let me use the words after a lapse of long time, the Act of 2019, having 107 sections, was passed, and it came into effect from 24th July 2020. And as per the latest available details, 14 rules and 6 regulations have been passed in pursuance of this act. You can see the source website consumeraffairs.nic.in. Now, my main focus would be on scope of research and learning in this area of consumer protection. I know that most of you are LLM students, and you might be in a search of topics for doctrinal work, non-doctrinal work, legislations, etc. So I have identified 11 topics or 11 points for your dissertation or doctrinal or non-doctrinal work. Number one, that is study of objectives of the Act in context to the enforcement and previous Act. Just through this selection of this topic, you can have the study, you can get the opportunity of studying the comparative study of objectives of the previous Act, that is Act of 1986 and Act of 2019. Moreover, you can compare the objective and the achievement of the outcome. So this will be the first probable proposed topic for your dissertation or doctrinal, non-doctrinal work. Then second, study of performance of Consumer Protection Council, section 3 to 9. Obviously, we know that it is an advisory body, but being a scholars of law, we should examine the function, the achievement, the outcome, year-wise outcome of these authorities. So we can recommend whether this special body should be continued or it is required to be omitted. Then fourth, Consumer Dispute Resolution Commissions, section 28 to 73. So particularly, there's a need of getting the data of numbers of monthly cases and appeals filed and disposed by commissions. We should actually find out here how many. Pardon? Okay. Then topic number 5, mediation. We know that this provision for mediation is a salient feature or main feature of our new enactment of 2019. So there's a need of study of this mediation provision, section 74 to 18, regarding the appointment, performance. We can see after the enactment of law, the process of appointment takes too much time, and the performance is also a matter of research. We should find out the performance of this mediation process of the mediators. Appointment, the performance, it is required to be studied. Then product liability, section 82 to 87. Personally, I have observed that due to this provision of actions against manufacturers and dealers, sometimes unnecessarily dealers become the victim. So there's a need of study of false cases against dealers. Of course, subsequently they can get their good defense, but first of all, either they have to be bribed or they have to face the action. Then unfair trade practice, section 94 is also required. And more important thing is rules making power. Study of rule making powers under section 101 and to 105. Study of latest rules and regulations, their impact, related suggestions. If you compare the Act of 1986 and 2019, we can see this more emphasis is given on the rules, and this power is given to the governments. So it becomes our duty to examine whether the particular rules have been framed in accordance with the provision of the Act, and whether we could get the results from the enactment or from passing of those rules. So it is necessary to examine the rules under section 101 to 105. Then role of Department of Consumer Affairs. If we go to the provisions of this Act of 2019, much more emphasis is given on this Department of Consumer Affairs. Consumer Affairs Department can contribute a lot. Then there is an expectation of significant contribution from Department of Consumer Affairs. Then company study of other foreign consumer laws. So we can suggest proper measures or proper provisions for our existing law. And then Details of demand of grant by the Department of Consumer Affairs, fund allocation for consumer protection in budget, actual utilization for filling vacancies, infrastructure, training, etc. All of you might have observed that in order to have a speedy trial, legislature makes efforts for quasi-judicial authorities like environment tribunal, consumer tribunal, motor accident claim tribunals, but we do not see the effective results. And the reason is lack of fund, lack of recruitment and training, etc. So it is also important to see what is wrong or where there is a problem for the effective implementation of the Act and rules. Now, I would like to shift to the criticism. The function of a researcher is not to say all is bad. He has to find out the gap between what is on paper and what is the reality. He has to examine the drafting of legislation, loopholes in execution, etc. Nowadays, empirical research is the lead of the day. Critical study contributes a lot in better implementation or better fulfillment of objectives. So, I have observed 8 points for criticism with the bona fide intention. Number one, delay in enactment. I am of the view that it was required to be enacted before 2010. So it took 10 years more. Lengthy and less effective in comparison to the previous act. It is lengthy, having 107 section, and it is less effective because it depends on other rules, delegated legislation, and compliance of those legislation. For example, filling up the vacancies and infrastructures and all these things. Then, instead of provision for mediation, there is a need of provision for speedy disposal. Just we should try to understand what is the purpose of special enactment. The purpose of the special enactment is the speedy trial. So there should be the provision in the act itself that the trial should be speedy. And mediation is one of the options. That means we have accepted that even though after passing the special enactment, we could not get the speedy, we could not deliver speedy justice, and therefore we have made the provision for this mediation. Committees for selection of members were required to be continued. In the past, that there was provision for selection committee for selection of members, and it was required to be continued. Need of the simple need for the provision for the simple and directly filing to redressal commissions in the act itself. Of course, section 17 says about e-filing to the district collector, but if we know about the burden, responsibilities of collector, and practically it is rather impossible to do justice by the district collector. It was required to be directly addressed to the concerned forum or concerned commissions. Of course, it is mentioned in the website code.nic.in that the government runs a portal called the Consumer Online Resource and Empowerment Center. It is run by Consumer Coordination Council and supported by the Department of Consumer Affairs. But it is required to be verified regarding the actual implementation and the result or the outcome. Then number 6, no provision for redressal in cases of deficiency in services by Department of Governments. This is the most important thing because every citizen is supposed to get redressal for deficiency in services by any department of the government because the departments are run by the fund derived from taxpayers. So, citizen is a consumer. All of you might be knowing that the court has decided that the pensioner is also a consumer. And if the pensioner does not get his retirement benefit within stipulated time, he is required to be considered, hence he should be redressed through e-filing. This is one example. There are numbers of such cases. Need of immediate and enough recruitment, infrastructures, etc. And need of immediate, short, less, and most effective laws and rules. So these are the points which I would like to point out. Then I would like to discuss some important case laws. Of course, I won't give details of all cases, but 4 or 5 cases which are more important according to me. First of all, the cases regarding Consumer Commission vacancies. All of you might have read what the Honorable Supreme Court says about this thing. Live law 10th November 2001 says Supreme Court warns states of exemplary cost if status report is not filed within a week. Supreme Court directs states except Maharashtra to fill up Consumer Commission vacancies by the end of January 2022. In suo motu case, live law 7 December 2021. All vacancies in state consumer dispute redressal commissions to be filled within 8 weeks, bar and bench 3 or 4 days ago. Number 2, regarding the compensation. So one interesting case, and that's why I would like to mention. Otherwise, there are numbers of cases. National Consumer Commission Delhi awarded compensation of 2 crore to a model for wrong haircut. 21st September 2021. Then Mumbai Consumer Commission ordered a matchmaker to refund 55,000 rupees to a woman for failing to provide 15 suitable candidates per month as per promise. So every person who is trying to get money from the people have to remain conscious. Recently, the Supreme Court ordered one insurance company to pay compensation even in case of violation of term of insurance policy, that is a goods carrier allowing the passengers. And if the scholars want to know more about this latest case laws, then I recommend the latest case laws on Consumer Protection Act by M. Govindarajan. He has written this book. And now it is said that the function of a law teacher is to teach how to learn a law, not all details of the law. You are supposed to know the information, and you are supposed to get the information through more reliable sources like Google and etc. I would like to conclude with an humble suggestion that the brief outcome of such conferences in form of a collective wisdom should be sent to the Department of Consumer Affairs and the media. Some of us are doctors, but before diagnosis and prescription, there's a need of all required true and perfect details available to us. Thank you very much. I've consumed very less time. However, if we want to discuss, then we can discuss about the paper presented by the participants in the previous section, particularly 5 or 6 candidates that presented papers before me. Thank you. Thanks a lot.
Yes, sir. Sir, kindly sum up your technical session. Kindly sum up.
Sum up? Sorry, sum up?
Kindly sum up your technical session. ગઈકાલનું technical session હતું ને, એ આજે
Yeah. Okay. Yes, in the technical session of Saturday, 7 participants had presented papers before me, and the first paper was presented by Ms. Twinkle Desai. Her paper was regarding the impact of the Act and Rule Act of 2019 and subsequent rules. She has nicely narrated the recent position of internet users. She has mentioned that 4.92 billion people are using internet during January 2022, and out of those 58.4% users are using the online marketing, or they are purchasing or buying through online marketing. She has mentioned about the clarity or definition of advertisement in this new act. She has also mentioned that the definition of consumer was broadened by including the e-consumer, and service providers, electronic service providers have been included in the definition of service providers. Then she talked about unfair trade practice, misleading advertisements, and particularly she mentioned about Section 17, okay, through which the consumer can get the redressal by e-filing to the district collector. So regarding this, I mentioned that instead of giving powers to the collector, it is required to be addressed to the concerned consumer redressal commissions. So she has nicely given the statistical data of the recent situation and the era of this e-commerce, e-consumerism, and e-consumer protection. If we adopt the e-commerce, obviously we have to protect the e-consumers, and e-consumer redressal remedy redressal should be available easily. It should be easily available. Then Ms. Bhavna has discussed about the constitutional perspective. Obviously, we know that there are some provisions in fundamental rights, Article 19, 21, and provisions in the Part 4, Directive Principle of State Policy, Section 38 and 39A. But one thing she has not mentioned, that even prior to these special enactments, the Supreme Court had taken note of the wrong advertisement on magic drugs and all these things. There was a case of Hamdard Davakhana. There is a fundamental right of business profession. Simultaneously, public interest is a paramount importance, is a more important thing than the right to business. And that's why in that case also, the Supreme Court had taken action against this unlawful or advertisement or wrong practice in the field of business, magic drugs and objectionable articles. So she has, of course, covered the relevant sections, articles, Article 19, 20, 38, 8, 39. Then next one is Sami Hassani. His topic was similar to Ms. Twinkle Desai with advent of e-commerce. At the time of this, the beginning of this e-commerce, what are the issues? And as mentioned, the provision of this three-tier quasi-judicial mechanism. Of course, it was already there in the previous act also, but now pecuniary jurisdiction have been increased. For district court is 1 crore, for state commission it is 10 crore, and for national commission about 10 crore. So these provisions were there, but now he wants to say that the consumers should get the remedy in the e-commerce also. And then Mr. Vijay Lakhera, he has talked about this insurance sector, right? He has rightly mentioned one important case, and the case law is that even beneficiaries are also considered as consumer. Obviously, policyholder is a consumer. There's no doubt regarding that. The policyholders should get the remedy, but not only the policyholder, but even the beneficiaries are also considered as consumer. It is a notable decision. Then Mr. Ajay Patel, he had talked about Central Consumer Protection Agencies, authorities. He has mentioned the relevant provisions of the Act of 2019. But important thing which is required to be mentioned is that so far as this Central Consumer Protection Authority is concerned, the provisions which have been mentioned in the particular act are required to be implemented with immediate effect. That is only the main point for the success or for the significant outcome of the act. And then last, Mr. Neelam Rathod, he has mentioned about, he has also discussed the e-consumer rules of 2020. And I highly appreciate the title, Key Implementation and Challenges. The researchers should obviously focus on the challenges. What is mentioned in black and white, it should be the reality, it should be converted into reality. What is the objective of the act or the rules? They are required to be fulfilled, and the function of the law scholar is to make the more effective legislative provisions, principal legislations, subordinated legislations, and we may get fruits. I think the people of India expect the best protection of interests of consumers through the Act of 2019. If the words are used in the statement of objection reasons of the bill for the Act of 1986 as a better protection of interest of consumers, because these words are nicely used or rightly used, because there were consumers, there were violations, there were remedies, but they were less effective, costly, and time consuming, and some people avoided to get the remedy due to this lengthy procedure. And that's why through the special enactment, the intention of the legislature was to provide better protection of consumers. So obviously we expect that in the statement of objection reasons for the Act of 2019, it should be the best protection of interest of the consumers. If we have, where there's a will, there's a way. If we have the intention of best protection, then obviously we can get the best protection through the legislative provisions and concerned authorities by rules and implementation of the same, and we can realize what is mentioned on paper can be get in the reality. Thank you very much.
Thank you, sir. It is a pleasure listening to you, Vikram sir. It is learning session for us teachers also. Thank you so much, sir.
Definitely.
Obviously, there should be the utility. It must be a utility-based lecture. Sometimes I know that the PG students are wandering here and there for getting the topic. Which topic should be I should select, and what should be written. So, only on one particular act, they can find out this such type of 10 different topics for this dissertation or doctrinal work or non-doctrinal work, and we can contribute a lot, and we can show our performance. Even it is useful for the next accreditation of the institution. Okay.
Yes.
If we send the outcome in a proper language, sometimes we may be in a bitter tone or whatever it may be, but you may mention in a polite and sweet words what we want to say, and
Yes, sir.
we at least we can get a satisfaction, self-satisfaction that we have tried our level best to contribution for the development of the country or for the welfare of the country.
Thank you. Vikram sir, JT sir, Shanaz ma'am, Manisha ma'am, તમને બધાને કહું છું, we are going to publish an edited book with ISBN number.
Very
કે તમારું કોઈ write up હોય તો just send
Yeah.
me, I will publish that book. Conference proceedings published as an edited book. So I will
Yeah.
include your write up
Yeah.
if you have time, please. Okay.
Okay.
Thank you, sir. Ankita
Okay.
ma'am, Akansha ma'am, please take over.
Yes, ma'am. Thank you, sir, for your knowledgeable learning session. I now welcome Dr. Manisha Shukla, ma'am, who is the in charge principal at MSK Law College, Bharuch. She is an ACE academician. She has published various research papers and has been a key resource person at various national conferences and seminars. Her passion for law is evident as she is most sought after by her students and colleagues. Over to you, ma'am.
Thank you,
Welcome, ma'am.
Thank you. Today I've got the opportunity to even listen to my seniors. Thank you, Irmala ma'am. With that, Today we have got, as Kamlesh sir also told, that our old colleagues and the new colleagues. So it's a happy day and a happy moment for us. And since Saturday, we are actually blessed with all the new papers on the new laws from the students as well as the teachers and all. So happy to know about many more things which maybe were left out for learning. And so we have learned. The JT sir just told that yes, we are learners throughout the life. So obviously, even we are learning so many things. And today I would like to talk something about the e-commerce and the internet banking, internet consumerism. So today I would like to just go on with the commerce perception towards e-commerce and completely a kind of banking or maybe the consumerism or whatever kind of consumers we have presently, and what are their attitudes, what are the changing attitudes of this consumerism. So I would like to stress on that. So first of all, I would like to tell you that electronic commerce is now experiencing a really a rapid growth. That is what we have seen last 2 decades, right? So we have come from, I could say that from the shoppings, that is door to door, or maybe from the shops to shops. From that, we went to the malls, or you can say D-marts, superstores, and all that. So where we could go for the consumerization of all that at one place, and that now we have moved on to the most commercial use of internet, and that is the development of e-commerce. So this is a scenario which has been changed since last few years. We have seen this change in last many years, as both the seniors have talked about 1986 to 2019. So 1986 to 2019, there was a rapid growth of internet and e-consumerism throughout the people, and we can see that the most young generation of India is now on internet consumerism. So that is what has the e-commerce has become an integral part of our daily life. Every day we are doing this commercial changes or commercial what we can say that consumerism on particularly internet. So the internet based economy is the most established virtual reality of the world today that we can see. So what is important is industrial, all kinds of business are now growing in the form of e-commerce. And on that basis, I would like to classify this e-commerce into the different categories. See, classification, that is, initially it was from business to consumer. Now what we see is business to business, that is the particularly manufacturers or the makers of that particular product is dealing with the dealers, the wholesalers or all that. So that is what business to business. Initially it was also that, but now it has got on internet more recognition. Like, then the second thing was business to consumers, and that was available as we have understood that from 1986 also we could see that business to consumers, as the word consumer was not there, but when 1986 came, we all became very much aware about the business and the consumers. So that concept was there. But the third concept which I'm going to talk now about, that is commerce, that is particularly commerce to business. Commerce to business, why we are talking about is that particularly what is my need, what is my requirement. I am now able to specify that, and those people doing the business would come to me and would try to find out the or fetch the customers related to particularly the way whatever my needs are, that they are ready to provide me with all that what are my needs. So that is what is consumer to business. And then there is consumer to consumer. Why we are talking about consumer to consumer is that particularly when we are talking about OLX. What is that OLX is? That particularly a consumer who has already used that product is now ready and willing to sell that product to the other consumer. So it is consumer to consumer, and this we could achieve only with the internet. When e-commerce actually came into existence, we could try to get commerce to that is particularly consumer to business as well as consumer to consumer. So these are the two new concepts which we have heard when we started with the internet services. So this is what is very important part of us. And thereafter, there is also a e-commerce between the companies and the public sector. So even there, that is government companies or something. So this is also a kind of business which already was there but only got recognition. So these are the five new classifications about the commerce, e-commerce. And now what is the benefits? Because when we start with the e-commerce, we must think about that what was the object of bringing the e-commerce, what was the object of internet, because we have started using that internet since long, and now we have gone to that extent that every day and now and then we are doing dealing our business, making the business with all that internet things. At present also what we are doing is a kind of business provided by the government to some private agencies to give us the Microsoft this particular platform to take the lecture. So this public sector has approached that particular company agency to deal with that. So this is also a kind of government business with the companies. So now this has given lot of benefits to us. So particularly the introduction of e-commerce has offered us the opportunities to business, including reduced transactions and specifically, I would say, search of the cost, closer relationship with customers. Then we have increased profits. Plus, we don't have to go from one market to another for purchasing the things on just the click. We get whatever things we want from the net. Obviously, there are so many benefits of it. At the same time, there are some lacunas also, because maybe older generation would not like to still do that commercial consumerism on this particular net, because there are a lot of other problems also. So if advantages are there of online shopping, that is save time, save fuel, or you can say particularly the save energy, comparison of prices, and 24 by 7 availability of the things. 24, whenever I want to go to the market, I can just click on the net banking, net internet, and I can directly go enter into the shops. I can see the variety of products. I can do even the comparison of the products with that. And with that I can get even the cheaper of the cheap things in the best of the best products. So all that is available to us on net, and that also at any hour where we are free to deal with. At the same time, as I told you, there are certain disadvantages also, because personally you may not get the time, personally you may not get the chance to check the things, because sometimes it happens that whatever product you have been asked for and the product which comes to your place maybe have some different things. Yes, we have that solution to that also, that we can just return that product within 7 days or maybe whatever time has been provided over there, and we can do so. So this is one of the advantages also, and the disadvantages also related to that. And the next is diminished instant satisfaction, because when I go to market, I purchase a thing and immediately I bring that to the house. And when I order for something, it may take 7 days, 10 days, or maybe more than that. Or maybe I get I after 2 days, 3 days, I may get the particular things out of market and something like that. And maybe that I'm not getting the product properly. So it may happen. Then there is a fear of security as well, because see, when I'm making transactions on net, I'm using my credit card, debit card, or whatever cards, visa card I am having. And as we know that we have a lot of issues of cybersecurity as well. So obviously that those consumers who are using that have many a time been cheated also. And a lot of money has been they have wasted also on all these things. So it happens only if we are dealing with the companies, or maybe government or public sectors and all that, we feel that our money is secure. But when we are dealing with the private sectors or small scale industries, or maybe when we are in dealing with the Amazon or Flipkart or something, sometimes we feel that we have been cheated on that. So e-consumerism, though it is important, sometimes disadvantages also make us stay out of it. Then the quality of product and the method, as I told you, method of payment also makes lot of problems for us. So all this what shows us that as there are advantages also for this e-commerce, there are a lot of disadvantages also for the e-commerce. And there must be some proper rules, as we have started with all this before 2019. So for few years we have ever been losing all those kind of money or security or whatever that in those period. But after 2019, the new act when it came into existence, we have got answers to all those problems which we were facing on internet. So now we have got the chances that we have got the rules to regulate the e-commerce. And this e-commerce on electronic media has helped us in many ways. So how this particular marketplace model works is, in this model the e-commerce operator does not maintain his own inventory, but particularly this model shows that you directly order to that particular person, and directly from the e-commerce, that after deducting that commission on Amazon, Flipkart and all that, work on this model, and directly the things reach to our house. So what happens is, here we have got the security in this particular act, that it is been regulated by 2019. As our seniors already told, that 2019 has made the provisions for the penalty, for even the imprisonment up to 6 months. So all that is very important and was was taken care in the act of 2019. And so now we can say that internet has become a more safe place for e-commerce. Till 2019, from so you can say the second decade of 2000, we can say that particularly the industry which was flourishing at a very great space was not secure till 2019. Now it has got more security. We can deal in this particular e-consumerism in a more better way. And we have got that all chances to deal with particular these models. So applicability of e-commerce rules to e-commerce entity, that all goods and services bought or sold over digital or electronic network, including digital products. Secondly, all models of e-commerce, including marketplace and inventory models of e-commerce, all e-commerce retail, including multi-channel, single brand, retailers and single brand retailers in single or multiple formats, and all forms of unfair trade practices across all models of e-commerce. Rule 2.1 of Consumer Protection E-commerce Rules 2020 has been taken care of. So I can say that now, as we have seen earlier also, that when 1986 Act came, we tried to provide complete security to all our consumers, as at that time there was no such internet access for e-commerce. But at that time, whatever commerce was going on, basically all were taken care of, and we tried to provide maximum care to the consumers. The same way is been done here, not only for the consumers but also the e-consumers, by making the rules of 2020. And so now we can say that rules which are applicable to the natural person carrying activity in personal capacity, or rules apply even if e-commerce entity not established in India but also established outside the India. So now the best and best opportunities are being provided to all for e-commerce and e-consumerism. I think for e-consumerism, this is sufficient, because only thing which we want to know is whether the person dealing on internet with the consumerism is safeguarded or not. And we can say that by 2019, as we have already discussed also, that once the judgments comes, once the interpretation of the act has been done in a proper way, we would be in a definite position to say whether the rights and the interest of all the consumers, that is e-consumers, are being properly protected or not. So still we need to give some time to the judiciary also to interpret in a particular way for the e-commerce. I'm really thankful to Irmala ma'am and all that staff members with the board of their members, and even the seniors whom we could listen to yesterday, even the judges, Shreya sir, and the way Shreya sir has explained everything about the consumerism. We are really thankful to you and to all the members also. Thank you very much, Irmala ma'am. If anything else you can ask me for, please. Thank you.
Thank you, Manisha ma'am, for always guiding and supporting me in all my academic endeavors. Thank you so much.
Thank you.
Who is now taking the session forward, Anisha madam?
Ma'am, it's Rakshita.
Okay, yes, Rakshita,
ma'am.
yes.
Thank you so much, ma'am, for such an insightful session. I now welcome Dr. Shehnaz Bilimoria, who is serving as in charge principal of DD Law College Navsari since 2005. She has secured first class and university first rank in Veer Narmad, South Gujarat University in LLB examination, and was awarded by the auspicious hands of the then President of India, Dr. APJ Abdul Kalam. Further, she secured first class and first rank in LLM Labor Laws Group. She has participated and presented many research papers in various international, national, and state level seminars, workshops, and symposiums. She has also published research papers in various law magazines, journals, periodicals, Gujarat Law Herald, etc. Over to you, ma'am.
Thank you. Thank you, dear, for your generous introduction. A very good morning to all of you. Respected dignitaries and my colleagues present here, though virtually, but we are meeting here. As this is a learning session, I would like to throw some light on the positive aspects of Consumer Protection Act 2019. There are numerous changes in the Consumer Protection Act 2019, but what I personally like the most is that about the digitalization. The new act has definitely inculcated various new provisions with regard to digitalization. This indeed is a very welcoming change, and it was very necessary for the overwhelming advent of e-transaction. Consumer rights has to be evolved accordingly. Now, moving ahead, there is a change in the definition of consumer also. In the definition of consumer given in the code, an explanation by way of clause was added to expressly include offline or online transaction through electronic means, or by teleshopping or directly selling or multi-level marketing in the expression buy any goods or hire or avail any service. There is also provision for e-filing. The new Act of 2019 has allowed for the complaints to be filed electronically also. That itself is very innovative. Hearing and examination of party through video conferencing is also welcoming amendment indeed. Seller's definition has expanded and now it includes e-commerce platforms also. Moving ahead to the judicial changes. There are pecuniary changes in jurisdiction. Given the inflation and taking into consideration the change in value of rupees, pecuniary jurisdiction was enhanced across all three forums. According to the new Act, district forum can hear matter where value of goods and services does not exceed rupees 1 crore only. State forum can hear the matter where value of goods and service exceed rupees 1 crore only. But under rupees 10 crores, National Consumer Commission can now hear matter where such value exceed rupees 10 crores only. This indeed is something very good. Enabling filing from place of residence or work of consumer. As per the provisions in the previous 1986, a consumer can file a complaint in the local jurisdiction of the firm where the purchase took place or the place where the seller's registered office is located. But the new 2019 Act now enables the consumer to file the complaint in the local jurisdiction at the place of their residence or place of their work as well. For provision pertaining to establishment of Central Consumer Protection Authority, as per Section 10(1) of the Act 2019, the Central Consumer Protection Authority was established to regulate matters pertaining to violation of rights of consumer, unfair trade practices, and false or misleading advertisement are prejudicial to the interest of the public and the consumer to promote and enforce the right of consumer as a class. To execute the function laid down in it, the CCPA also enjoys a wide range of powers, including but not limited to inquiry, investigation, direction for producing documents, recall of goods or withdraw services, imposition of fine, restraint, false advertisement, etc. The function of the CCPA is regulatory, investigative, and adjudicative simultaneously. That itself is a very good change in the new Act. The concept of product liability has been introduced in the Act, which affixes the liability for faults in goods as well as services to the product manufacturer, product service provider, and the product seller. The interesting aspect of the provision is that now the liability for the product is attached towards the manufacturer than the seller. The Act 2019 also makes certain exceptions to this liability, where the consumer is primarily at fault and the product has been misused, altered, or modified. There is also an introduction of unfair trade practice. A broad definition of unfair trade practice has also been introduced under the Act 2019. This definition specifically covers a broad range of unfair and deceptive practice in promoting the sale, selling, or use of any goods or services. This includes making of false statement in regard with goods or services, false representation, guarantees not based on proper testing, and, in general, misleading the public. There are also provisions for penalty against false and misleading advertisement. That was indeed also very much needed. In an attempt to curb misleading advertisement, the Act 2019 has granted wide powers to CCPA to curb misleading advertisement. The CCPA, after investigating that an advertisement is false or is misleading and is prejudicial to the interest of any consumer or is in contravention of consumer rights, by order issue direction to the concerned traders or manufacturers to endorse, as the case may be, to discontinue such advertisement or to modify the same in such manner and within such time as may be specified in the order. Notwithstanding the order, the CCPA may impose penalty in respect of false and misleading advertisement to the tune of rupees 10 lakh only, or imprisonment for up to 2 years. In case of subsequent offence, the CCPA can enhance a fine up to rupees 50 lakhs and up to and up to 5 years of imprisonment in case of subsequent offence. In sum and substance, the legislative intent under the Act 2019 is to make the endorser cautious of the advertisement they may be endorsing. That is, the film star or the hero who endorsed such sort of advertisement. The last and most of one of my favorite is the introduction of, though it was, but more in a more rightly manner, introduction of alternate dispute resolution mechanism in the Consumer Protection Act for the cost-effective and speedy disposal of matter by the legislator. The Act 2019 has been included in Part 5 of the Act, which includes mediation. The Act 2019 provides that every procedure or every proceeding before the state, district, national commission where element of settlement exists which are acceptable to the parties shall be referred to mediation. That itself is a very welcoming step. The central government recently, on 15 July 2020, notified Consumer Protection Mediation Rules 2020. The said rules, however, clearly listed out matters which under no circumstances can be mediated, such as matter relating to medical negligence resulting in death or grievous injuries, matter relating to public interest litigation, matters involving serious allegations of fraud, fabrication of document, forgery, impersonation and coercion, matter related to criminal prosecution and non-compoundable offense, etc. Furthermore, to make mediation more effective, a consumer-friendly, all the expenses incurred in the mediation process, including the fees for the mediator, is to be borne by the state or the union territory. Now, one can clearly state and one can clearly say that consumer is no doubt the king, but consumer is a king with more power due to the amendment in 2019 Consumer Protection Act. And that empowerment was very much needed for each and every consumer. As Mahatma Gandhi has rightly stated, consumer is king and we should respect him. He is there for our profession. It is our duty to serve him to the fullest. So now, due to the new provisions and due to the basics and new amendments, the consumer is now more empowered and he will be in a better position to sue for even online transactions, e-commerces, and anything and everything related to ICT, that is Information and Communication Technology and Information Technology. So Consumer Protection Act 2019 can be considered as a very welcoming step for the actual empowerment of consumer as a large, including the expansion of definition of consumer and including e-commerce in it. So with this, I would like to end my presentation. Once again, I would like to thank Dr. Nirmala Dayal Madam for giving me an opportunity to be amongst you all and for giving us an opportunity to listen to our gurus especially Dr. Vikram Desai sir, Dr. J.T. Desai sir, Dr. Manisha Shukla madam, and no doubt Nirmala ma'am herself is very much expertise and very much talented and is a good orator. So it's always good being with you all. Thank you all. Thank you.
Thank you, Shanaz madam, a very dear friend, colleague, and a senior, without whom all this is not possible. Thank you for supporting me.
So
always.
nice. Always
Thank,
welcome.
thank you, ma'am, for your insightful detailing on the topic. Now we will commence the first technical session of our second day of conference. The session chair for this technical session are Dr. Fainal Billy Moria ma'am and Dr. Harshad Rawal sir.
Madam, just a minute. I will talk with Harshad. Bhai has not joined, I think.
Yes,
Just
ma'am.
a minute.
Hello. Harshad sir is in exam. I'll just ask him to join, please.
Okay, thank you, ma'am.
Okay.
I just talked with Bhadresh ભાઈ અત્યારના નહીં જોઈન થઈ શકશે એટલે જેવા હર્ષદ સર જોઈન કરે અનિશા મેમ પ્લીઝ સ્ટાર્ટ ધ સેશન.
Okay, ma'am.
I think Harshad sir has joined. Welcome, Harshad bhai. Welcome.
Namaskar, Harshad bhai.
Yes, ma'am. Yes, ma'am. I was in
Anisha-
exam, so
I understand, sir. I understand. અમારે ત્યાં બી એ જ હાલત છે આજે. શહેનાઝબેનની બી એ જ પરિસ્થિતિ હશે. પણ certain things are not in our hands, madam. હું શું કરું?
But it's okay.
We are managing. Anisha ma'am, please continue.
Yes, ma'am. Good afternoon, sir. Now we shall commence the first technical session of our second day of conference. The session chair for this technical session are Dr. Fainal Billy Moria madam and Dr. Harshad Rawal sir. Dr. Fainal madam, who is serving as in-charge principal of DD Law College, Navsari since 2005. She has participated and presented many papers at international and national level. She has also attended lots of national and state level seminar workshops. She has published many research papers in various law magazines and journals. Dr. Harshad Rawal sir is assistant professor at MSK Law College, Bharuch. He has completed his LLM in criminology group and doctorate degree from V. Narmad South Gujarat University. He has completed his MA in English literature. He has 12 years of experience at UG level and 9 years at PG level. He has participated and presented number of papers at international and national conferences, number of research publications in various law journals. He has also delivered guest lecture in many educational institutions. Thank you, Dr. Fenad Madam and Dr. Harshad Rawal for making time for this conference and for being session chair for the second session of the national conference.
Absolutely, our pleasure. Anisha ma'am, would you please read out the rules like 7 minutes of presentation and all to all the participants?
Yes, ma'am. Before we commence this technical session, I would like to inform all the participants that each author gets 7 minutes to present his or her paper. I request all the participants to please mind their time. Thank you. The first paper presenter is Dr. Bhaumik Upadhyay. His paper title is Awareness of Seller Beware as per New Consumer Law. Dr. Bhaumik, sir.
Good morning to all. Good morning to all. Today I am Bhaumik Upadhyay. Just a minute. Good morning to all. My topic name is the awareness of seller beware. Let's the beware from seller. In new term, new technology, in new era, we need to beware seller. Particularly, and main reason is that always buyer beware. This is the secondary matter. More in this digital economy, more than 85% work or transaction done by pending seller always unpaid because of pending credit, because always credit based analysis all मैं ये कहना चाहता हूँ कि क्रेडिट बेस्ड वर्क और क्रेडिट बेस्ड ट्रांजैक्शन इफ आई वांट टू द बाय फोन आई पे बाय नावी आई पे बाय HDFC बैंक एंड दिस इज for that reason seller need to beware in the news era. If the question of right to equality in labor law means labor friendly laws, in consumer law all laws are friendly to the consumer, but we're missing the main and important part, carefulness for the seller. We need seller always not cheat a buyer, sometimes buyer also cheat this seller. And main thing is the caveat venditor. Caveat venditor means beware seller. Let's beware to the seller. Your customer, you must need to know KYC, know your customer before advance sale of the production. When you sell your product, sale of good act as well as the consumer provision directly or indirectly deal with the concept of the buyer beware. We need let's seller beware, because in this financial era all the transaction in digital era for plastic money, and plastic money directly or indirectly cheating is possible. So far, for when we need to understand that all the seller not be unpaid. If you are unpaid or paid by the third party, then you know your buyer legal composition in a first sale, as well as the preserve your right. Once you sell the product without taking the money, then seller are unpaid and buyer is fully paid, because buyer get the product and consume. अगर मैं बॉर्नवीटा लाया पी गया बाद में पैसा नहीं दिया तो सेलर क्या कर लेगा? अगर मैंने वड़ा पाव खा लिया बाद में मैंने पैसा नहीं दिया, सेलर क्या कर दिया? और सो मैनी टेक्नोलॉजी है कि पेटीएम की एक एप्लीकेशन आती है, अगर मैं मेरे मोबाइल में स्टार्ट कर दूं तो आपके मशीन में बोल रहा है ऐसा दिखेगा कि 20 रुपए पेटीएम के अंदर आ चुके, पर एक्चुअली नहीं आए हुए हैं और वो बंदा वहां से चला गया. Then after, what is a possible solution for the seller? This is my main part and main question of, और इसके related इतने amendment हुए फिर भी right to equality not follow in a current consumer law as well as the sale of the good है. बस मुझे इतना ही कहना है. Thank you. Any question? This is my main part of my research paper.
Yes, Bhaumik bhai. Nicely presented your paper and a very interesting topic indeed. But do you have any cases relating to it? Have you mentioned in your research paper?
One case regarding the Yes Bank versus मैकडोनाल्ड की मैटर में किसी ने 30,000 रुपीज का खाना खा गए थे और यस बैंक के क्रेडिट कार्ड से पेमेंट कर दिया था, लेकिन पेमेंट उसे नहीं मिला था, और ये 2019 का केस है मैम.
So you talked about various amendments for the benefit of sellers. So
No,
what are
we missing some various type of amendment in current law. राइट टू इक्वालिटी लेबर लॉ में भी ले आए, लेबर फ्रेंडली थे, उसका हमने एंटरप्रेन्योर फ्रेंडली कर दिया. तो अब कंज्यूमर में भी जाओ, कंज्यूमर में भी सेलर फ्रेंडली करना चाहिए. मोर देन 85% मैटर में कंज्यूमर ही जीतता है, सेलर नहीं जीतता.
Bhomik bhai, do you mean there needs to be a seller protection act also, like consumer protection?
You need a seller protection act, मैम. गलती किए तो सेलर नहीं. अगर मैं रिक्शा लेके जा रहा हूँ, साइकिल वाले की गलती थी, फिर भी रिक्शा वाले को ही प्रॉब्लम होगा, साइकिल वाले को नहीं. ऐसा ही है. इन mantra.com में मैम मैंने 10,000 का सूट ले लिया, 2 दिन शादी में पहन दिए, मैंने उसको वापस कर दिया और मंत्रा ने सेलर को वापस कर दिया. ऐसा मैंने 4 बार किया, तो कस्टमर ने ही एक ना एक प्रोडक्ट फ्री ऑफ कॉस्ट यूज किया. अब सेलर ने 4th टाइम वो वापस नहीं लिया. मैं हर बार शादी में किसी के प्रसंग में जाने के लिए मंत्रा के वहां से 1 डे पे वापस डिलीवरी दे सकते, उस बेग पे मैंने वापस दे दिया. पहली बार दे दिया, दूसरी बार, 4th टाइम मंत्रा अंडरस्टैंड चीटिंग फ्रॉम द कस्टमर. उसने 4th टाइम मेरा सूट वापस नहीं लिया. मैंने कोर्ट केस किया, मैं जीत गया और मंत्रा हार गया. दिस इज द रियलिटी.
Right. Okay. Harshad bhai, do you want to ask something?
No, ma'am. You have already asked so many questions. That's why.
Thank you, Bhomik bhai. Very nicely presented. Thank you. Yes, Anisha ma'am. Next.
Thank you, sir. Our next paper presenter is Miss Hina Soni. Her paper title is A Critical Study of Consumer Protection Laws in Case of Online Shopping in India. Hina, madam.
Good morning, one and all. Myself, Hina Soni. I am a research scholar. The topic for my presentation is a critical study of consumer protection laws in case of online shopping in India. That is, we can say e-consumer. Slide, is it visible?
Not yet, beta.
Please try again, madam.
Yes, I am trying. Is it visible?
No, no yet.
Anisha, if we have their presentation, even we can share.
Okay, ma'am. Unless the Anisha ma'am is trying to start the PPT, till then I'll start my presentation. A dream of a digital India where access to information known no barriers. I dream a digital India where the citizen is an empowered citizen, said by Narendra Modi. As we all know that business are constantly innovating new technologies to adopt and evolving challenges in the area of e-commerce. The main drives underlying the e-commerce growth is the rise in the number of individuals who are using information and communication technology as a platform for trade. As we know, e-commerce also provides better access to information, which also allows us, the consumer, to discriminate among diverse goods and services available. E-commerce has given so many options, so many platforms to consumer to buy the product at their convenience, at their space. But still, there are a number of cases, they are evolving even after the new Consumer Act 2019. So the object of my topic here is why we want more research in this particular area. What are the changes that are described in object? Firstly we need to know what are we can say what are the misconduct that took place at the time of e-consumer. Firstly, insufficient information and disclosure that is provided on e-platform. Secondly, terms of contract, that is no full contract is in certain times described on the contractual agreement. Secondly, merchandise and delivery practices. Fourthly, payment. The payment conditions are not generally described. Some individuals who are used to the method, they can discriminate the methods, but others who are new to such platforms, they cannot get the clear idea about the payment conditions. Then transaction confirmation and cancellation policies for the purchase of the product. Then fraud and deception. Then unsafe product, confidentiality and any information which consumer provides. Like if we serve anything on the net, on the second phase, we can say the same notification when we are surfing anything else. Means what? When we are surfing something else, we get the notification of what we are surfing before. So this is one kind of fraud, or we can say this is one kind of data misinterpretation that took place on e-mode. Secondly, goods delivered should correspond to the description, quality and quantity for which the consumer has paid for. So all these are misconduct that took place at the time of e-transaction. So my object for today's paper is first, to examine an administration and enforcement of consumer laws in online shopping bought before the dispute redressal agency and suggest measures. Secondly, to ascertain the need for further government actions on regulating consumers' access to adequate and authenticate information on online shopping platform, and to identify the extent of the consumer awareness and suggest further steps to strengthen the consumer education and awareness about the new market phenomena. The hypothesis of my subject is the Consumer Protection Act 2019 and e-commerce rules have made an effective effort to cope with the issues related to e-commerce. And secondly, the traditional system and procedures that have been followed for the e-commerce issues. Research plan. For the purpose of this research paper, the secondary sources of information of e-books, research papers, journals and cases have been referred. And secondly, also refer the online complaint portals like National Consumer Helpline and its basic mechanism, like how it's working, what are the complaints that you can register on the same. Now, new rules that have introduced in e-consumer 2019. Firstly, the Consumer Protection Rule 2020 notified under the Consumer Protection Act 2019, and which aims to prevent the unfair trade practices and protect consumer interests and rights in e-commerce. The first we can say rule is it talks about the applicability of the article. So it is applicable on the electronic, on the each and every sale and purchase that took place on electronic mode. Secondly, e-commerce in retail. Thirdly, e-commerce entities, whether they have inventory or marketplace model. Second, general duties of e-commerce entities. Rule 4. It talks about the company incorporated under the Companies Act, then appoint a point of contact to ensure compliance with, then imported, if the goods sold on the e-mode is imported goods, then the seller is buying, that he has to display all the details on the product. Secondly, cancellation charges on consumer unless they bear similar cost and affect all payments toward accepted refund request of the consumer within a reasonable period. Then liabilities of marketplace e-commerce entities. It talks about the e-commerce entities and their liabilities. The e-commerce entity requires sellers to ensure that the information about goods on their platform is accurate and correspondent with the details. Secondly, the details about the seller offering goods, principal geographic address of its headquarters. Thirdly, separate ticket, docket, complaint number for each complaint lodged through which the user can monitor the status. information about the return, refund, exchange, warranty, guarantee, information on the method of payments available to protection of such firms, and they would make reasonable efforts to maintain a record relevant information. Then it talks about the seller's duties. Now, the authorities they have been assigned for the consumer dispute redressal regarding e-commerce are also described in the new rule in a new way. These authorities we can say is Central Consumer Protection Authority, redressal mechanism, and mediation. All these three authorities work on the basis of consumer complaint, their amount of complaint, and their compensatory amount that they ask for. Basically, all these is a quasi-judicial mechanism authority which settle the matter of consumer complaint. Now, conclusion and suggestion. The said new amendment will definitely minimize the issues related to e-commerce if it's get applicable to the same way. But as the transaction get increased, the cases might also get increased, which needs a speedy redressal, and for that we need more forums, mediation centers, and other redressal addressing agencies to avoid the burden of cases. As per the new Consumer Protection Act, the District Commission has to decide which cases can go to mediation and then direct the cases to the mediator. This will bring the personal discretion and delay. The complaint should given to option to the apply mediation as the first option. Only if the opposing party refuses to accept the mediation, then only they should go before the commission. Court fees are payable on the basis of consideration paid, regardless on the compensation claim. He said that this will lead the filing of inflated and exaggerated claims to capitalize upon the deficiency in services. In short, the new amendment has made so many mechanisms and provisions for the protection of consumer, but still there is less awareness regarding that. So consumer need to get aware, as well as the new mechanism and new systems also get adequated with the consumers. Thank you. That's it.
Thank you, Ms. Hina. Now you have selected the topic on online shopping in India.
Yes,
what
ma'am.
are your views on online shopping? Is online shopping bad?
No, ma'am. If we do online shopping with precautions, then there is nothing bad in it. But firstly, we need to get aware with it.
Can you please enumerate some of the precautions?
Like when you are asking for payment, then you have to if you are not sure with the payment option, then you have to opt for cash on delivery. Secondly, if you go for a return policy, if you want to return the product in future, or if your size or any issue is there in that particular case, you need to get aware before purchasing with the return policy of that product or of that particular platform.
Okay. You have mentioned somewhere in your presentation seller's duty. Can you
Yes,
explain what are the seller's duties?
Seller's duty is like a seller has to take some actions if the goods that seller is selling in the market are imported from another country or another manufacturer, then he has to mention the detail or that particular detail on the product. Secondly, it is mentioned in the rule that he would have a prior return contract with the e-commerce, that is the seller. Suppose Amazon and Myntra is there and they are purchasing product from another individual and selling to another individual, so they need to have an e-contract in advance with the seller as well as the purchaser. He would appoint a grievance officer. Every individual seller or platform need to appoint a grievance redressal officer to whom they call their call center number or anything, who can resolve the query at the stage of initiate only, and it should not get forward in the court or like mediation if the purchase and seller both are genuine.
Okay, thank you. Yes, Harshad bhai. Dr. Rawal sir.
in specific and tech. Audible?
Dr. Harshad Rawal, if you would like to ask something to Ms. Hina Soni.
No.
મેમ લાગે છે ત્યાં કનેક્ટિવિટી ઇશ્યુ છે. We move on to another participant. Sir, end માં બેન અહીંયા જશે, થોડી વાર રહીને પૂછીશું.
Sure.
Thank you. Our next paper presenter is Ms. Avni Chauhan. Her paper title is Sustainable Consumption, Green Living Through Green Buying. Avni madam. Good morning, one and all. Here I am presenting my paper on the sustainable consumption, green living through green buying. We all know about the sustainability, where it come from and where it, what is the meaning of the sustainability. Next slide. Here I am presenting my object on the paper is that impact of the sustainable development goals on the Indian consumerism, and the second object I cover is that the implementation of the sustainable development goals on the indigenous worlds, which cover the real facing problem. I use the secondary data collection method for the doctoral research, and my research problem covered the three main parts. First is the applicability of the sustainable development goals for the sustainable consumptions. All the signatories fulfill the sustainable development goals completely, and the last one is that India has adopted the sustainable goals. Next slide. What is sustainability? Very first meaning, we all know that sustainability, that means we use, recycle and reduce. There is not end the sustainability. Sustainability means meeting our own needs without the compromising the ability of the future generation to meet their own needs. The origin of the sustainability will come from the Latin sustainer, which means tenure, to hold, or to sub, or to under. Next slide, please. Next slide. The very first sustainable development concept come from the Brundtland Commission's 1987. Please revise it. Thank you. The definition of the sustainable development come from the Brundtland Commission in 1987, meeting the needs of the present without compromising the ability of the future generation to meet their own needs. The very first definitions they given in this Brundtland Commissions, they also given the three pillars in the Brundtland Commission's report. Next slide, please. Economic, social, and the environmental, social, and the economic. The environmental pillar talk about the sustainable human activity must protect the years of the survivor, and the social pillar covers the people in the community must be treated fairly and educated, particularly regarding to the environmental explorations of the all countries and the community. And the very last economic pillar covers the human development depends on the long-term productions, use, and management of the resources at the plan of the global economy. Next slide, please. All three pillars cover the sustainability: environmental, economic, and the social. Next slide, please. Introductions. The motive come from the sustainable development at the very beginning in the 1992. The motive was initially spotlighted the Rio Earth Summit in 1992. 179 government has endorsed the principle of the Agenda 21, UN 1992, at the UN Conference on the Environmental Development Earth Summit from the June 3rd to 1992. Next slide, please. Next slide. Here now we first talk about the Rio 1992, also called the Earth Summit 1992. As we already talked about, the 190 country were the signatory and the pledge to achieve the sustainable development by the 2010 Agenda 21. Agenda 21 is the outcome of the Earth Summit 1992. Agenda 21 is the blueprint for the sustainability in the 21st century. The 21 indicate the 21st century. Deals with the poverty, overconsumptions, health, and education. Let me highlight the meaning of the overconsumptions. The action or the fact of consuming something which lead to excess. There were 5 ways to reduce the unnecessary consumptions. Very first is that bring on the solar power, travel green. We can include a solar car, electric car. Third one is the buy sustainable economic materials which are reused and recyclable. Donate old clothes. Don't consume your future need at the present. Just consume what you need at the present. Promote roles for all. Every local government for each country has its own Agenda 21 for fighting against the environmental problem. In short, it contained 27 principles that were supposed to guide countries in the future sustainable development. It mainly was to achieve global sustainable development by 2000, but the main loopholes of the Agenda 2021 was not binding in action plans of the United Nations with regard to the sustainable development. There were also 2 outcomes of the Rio 1992. Very first is the Kyoto Protocol, and the second one here, which deprivations are due to regarding the consumptions of the excessive fuel, then pollutions council. Very first guideline by the given in the 1985. Next slide, please. Next slide. Next slide. Next slide, please. Okay, here we have the 3 guidelines. First guideline come from the 1985, 1999 and 2015. There were little modifications in the 1999 and the 2015 guideline. 1985 talk about physical safety, productions and the protection of the consumer's economic interest. Third one is the standard for the safety and the quality of the consumer goods and services. And the fourth one, distribution of the facility for the essential consumer goods and services. And the last 3 one is that measures enabling consumer to obtain redressal, and the very last one is a measure relating to specific areas. These all are covered in the 1919, but they were one highlighted guideline is that guideline G, the the promotion of the sustainable consumptions. Next slide, please. And the very last guideline talk about the recently 2015. They were include new 3 guidelines. Very first guideline is the national policy for the consumer protections, and the last 2 one is that electric commerce and the financial services. Next slide, please. These are the 17 goals which given by the United Nations for the sustainable development. Here the number 12. Next slide, please. Here the number 12 specifically refer to the consumer productions or consumer consumptions, responsible consumer and the productions. Here the goal number 12 talk about the reducible materials, use the recyclable product. Next slide, please. The adoption of the sustainable development goals in India. India adopt out of 15 out of the 17 SDG directly related to activity undertaken by the local government. Like we refer to the new Consumer Protection Act 2019 to include the scrappage policy. Scrappage policy is all about that you can if you having a motor which already 10 or 15 years old engine consume, and if it throws out lots of fuels or lots of pollutions, you can just give it to the bank, you can give it to the government, they give you nice remunerations. They can also include this in the scrappage policy. They also include the new product safety. They also include the new any just a second, hold on. They also include the new materials which cover the recyclable and reusable. Next slide, please. The Sustainable Development Agenda 2030. After the completions of the 2015 Paris Agreement, it declared the Agenda 2030 as it declared the Agenda 21 for the 21st century, just for the over the period of the 10 years. But after the Paris Agreement 2015, they also included Agenda 2030. Agenda 2030 talks about the 5P. First is the people, second one is the prosperity, third one is the planet, and the fourth one is the partnership. The last one is the peace. The Agenda 31 more and more emphasis on the consumerism, green buying through green living. Next slide, please. Okay, here. I want to recommendations, put my recommendations like the reliability of the sustainable consumption in the deprivations in the actual world, like this. So the sustainability in the other way, and in the actual world there are some other sustainability. The awareness of the recycled products is lacking among the consumers. The fulfillment of the sustainable consumption goal toward all the signatory, everyone is not following, because the Agenda 21 is not binding to all. Okay, it is just individual initiative. And the last one is the switch to more sustainable consumption in the productions pattern. Here I am submitting, ending my paper. Ma'am, if you have any questions, you can ask.
Thank you, Avi. Very nice topic indeed, and very well presented.
Thank you, ma'am.
You have mentioned the word balanced global economy. Can you elaborate what is balanced global economy?
Balanced global economy is all about we all in the world, like we have less fuels consuming, like 2050 પછી કોઈની પાસે પણ એટલું બધું fuel રહેવાનું નથી. Okay, and the global economy is all about you can say that Ukraine and the Russia. Russia want the essentials with the Ukraine having. This is a effect of the global consumption economy.
Okay, right. So you did mention the Sustainable Development Agenda 2030. Who introduced this? Where did you get this from?
It is come from the 2015 guideline of the United Nations for the consumer, on the consumer.
Okay. And can you please elaborate? Don't consume your future in present.
Just remember, could you please repeat it?
Could you elaborate or explain the term or the maxim that you said, don't consume your future in present? Keep
I'm elaborating. Yes, sorry ma'am, there is a little disturbance here. I'm just elaborating, just like if you just want to consume your present need, just consume that only. Don't consume overconsumptions. Overconsumptions lead to the global economy effect. If you want to consume just your present need, just consume your present need. Okay, we having the corona effect, we all suffer from them.
Right. It also applies to wastage. Wastage of food, it applies to wastage.
Yes, ma'am. Same here.
Electricity, everything and anything that we have very limited sources.
Wastage of the. Yes, ma'am.
We should keep it reserved for future generation also.
Sure, ma'am. Wastage of also electricity.
It includes tree and all. Very good. Very nice. Yes, the next one. Thank you. Sorry, Harshad, if you
Yes,
want
ma'am.
to ask something. So,
No, no,
We are also facing the yes. Ma'am. Okay.
thank
no,
you.
ma'am, no
Avi.
more questions.
Even we are facing the e-test also.
Thank you.
Thank you, ma'am.
God bless.
Thank you, ma'am.
Anisha Ben, should I declare the next name? You are there.
Yes,
Sorry.
ma'am. Thank you, Avni. Now I would like to invite Miss Akansha Jain. Her topic is Comparative Study of the Consumer Protection Act 1986, the Consumer Protection Act 2019.
Thank you, ma'am. Good afternoon, everyone. I'm Akanksha Jain. I will be, just give me a second, I'll be sharing my screen. Okay. Is my screen visible?
It's visible. Yeah, it's visible, dear. Continue.
Thank you. Thank you. Okay, my topic of research is comparative study of the Consumer Protection Act 1986 and the Consumer Protection Act 2019. See, first of all, what was the need for making amendments and introducing 2019 Act? Main reason for that was to make the law adaptable for coming changes. Like we know that environment is a ever changing thing. So to make changes in the to make law according to the environment, there was need to update consumer protection. Okay. Secondly, for increasing the redressal mechanism, like earlier there were no mediation provisions and everything. So to increase that, for making it easy for people, e-consumers and everyone, it was the need of our to amend the Consumer Protection Act. If we see on the screen, it's shown that Consumer Protection Act 1986 has been changed so many times. There are so many amendments which were introduced before 2019 Act was introduced. To look to the 2019 Act was passed. First, the 2019 bill was passed in Lok Sabha on 6th of July 2019. It was introduced and passed on 13th July 2019. Then it was passed to Rajya Sabha on 6th August 2019 and received assent of President on 9th August 2019. Thus, we can say that Consumer Protection Act 2019 was enacted on 9th of August 2019. The objective of my research is to compare legal provisions of Consumer Protection Act 1986 and Consumer Protection Act 2019 and to identify merits and loopholes for effective implementation of Consumer Protection Act 2019. If the hypothesis of my research was whether the statutory provisions of Consumer Protection Act 2019 are implemented in its true spirit and whether the alternative dispute redressal mechanism which has been introduced is effectively put in practice. Before comparing both the acts, I would like to say that there are various features which were specifically introduced in 2019 Act. They are like rights of consumers were redefined. Okay, there was specially Consumer Protection Council which was made. Central authority acted as a regulatory body. There was we all knew that there were unfair trade practices and misleading advertisements. So to overcome them, Consumer Protection Act 2019 was introduced. Okay, there was enhancement in jurisdiction of commissions. Then for e-commerce, from e-commerce perspective also there was a need for Consumer Protection Act 2019, and now we have e-filing of complaints as well in Consumer Protection Act 2019. Now if we compare 1986 Act and 2019 Act on the basis of pecuniary jurisdiction, we can say that earlier there was District Forum, State Commission and National Commission. So District Forum pecuniary limit was up to 20 lakhs. Now currently in 2019, it is up to 1 crore. Similarly, in State Commission, there was the pecuniary jurisdiction was 20 lakhs to 1 crore, and now currently in State Commission, it is from 1 crore to 10 crores. National Commission, earlier it was 1 crore and above, And now in National Commission, it is more from 1 crore and above. Sorry, now it is 10 crores and above. Secondly, if we go for comparing on the basis of MRP or purchase price, we can say that earlier pecuniary jurisdiction was the criteria was based, if we have to decide if the case would go in which jurisdiction, it was earlier on the basis of MRP. Now, what is the actual price? What is the discounted price? They are the criteria to decide the pecuniary jurisdiction. Thirdly, if we go for territorial jurisdiction, we can say that earlier it was where the seller had his office, only that territory, only there one could file a complaint. However, now where the complainant resides or works are the place where 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 the complainant can file a complaint. Regulator, we can say that Consumer Protection Act 1986 did not have any specific regulator. There was no such provision for regulator. And 2019 Act has Central Consumer Protection Authority, which is formed, which acts as a regulator for everything. Next is mediation. 1986 had no mediation provision. However, in 2019, one can see that court can refer any case for settlement through mediation process under Section 80. Next is appeal. Earlier, there were 30 days period for appeal. If anyone is not happy with the judgment of district forum, they could appeal within 30 days. And one had to pay either 50% or 25,000 as a deposit. Now, in appeals, there is 45 days time period if one needs to appeal against any order of district court. Next is e-commerce. There was no specific mention of e-commerce in 1986 Act, and now there are now all the provisions in 2019 Act are applicable directly to seller and has been extended also to e-commerce. Earlier, there was District Consumer Forum had no rights, had no powers actually to review any decision. However, now District Consumer Forum has powers to review. There were currently, if we see unfair terms and conditions, there were no such provisions for unfair trade terms and conditions. However, according to Section 49, subsection 2 and 59, subsection 2, the new act gives power to State Commission and National Consumer Dispute Redressal Commission to declare any term which is unfair to consumer as null and void. Authority, if we see, there were earlier District Consumer Forum, State Consumer Forum, and National Consumer Dispute Redressal Commission. Now we have District Commission, State Commission, and National Consumer Dispute Redressal Commission. If we see composition of State Commission, so there has been a change. The change of president. Earlier there was a member, president, and 2 members, and now we have president and 4 other members. This was comparison between Consumer Protection Act 1986 and Consumer Protection Act 2019. I want to conclude that 2019 has been Consumer Protection Act 2019 has made various changes, and these amendments have increased the scope and definition of consumer product liability, misleading advertisement, unfair trade practices. Everything comes now under 2019 Act. Established expeditious dispute resolution process to resolve the grievances on fast track basis, included online marketplaces and online auction sites under the purview of aggregator, instituted authorities at district, state, and national level for consumer dispute redressal, and ease the process of filing of complaints through electronic means, which is boon for consumers. Established responsibility on producers and manufacturers and service providers. For recommendation, I would like to say that even though mediation has been adopted, okay, but the procedure is not completely well established according to the need of consumers. They are available, but there is a lack of acceptance of this procedure. Okay, and secondly, the pecuniary jurisdiction amount has been reduced. If we see in 2000, it has been reduced to 5 lakh rupees, which leads to false complaints as well. This has increased the false complaints, and thus justice given by the courts would be less than the cases filed. And there is dire need to educate consumers, and proper measures must be taken to build awareness among the consumers. Uh, then there are various countries which have stopped their celebrities from endorsing an unhealthy foods, thus reducing damage to consumers. Thank you. Now, ma'am, if you have any question, I will.
Thank you, Akansha. Very nicely presented. Harshad Bhai, if you would like to ask few questions to Akansha Jain.
Yes, what is the new challenges for the new CP Act?
So for challenges, you can say they are trying on their level best, but they are not able to completely, like I told you about ADR procedure. However, they have made procedures for ADR for mediation. However, not everyone is willing to accept these procedures. And even though they have reduced the pecuniary limit, but this increases burden on the on courts. I feel these are the some of the challenges which are faced due to CP.
Akanksha, what according to you? Thank you, Harshad Bhai. Akanksha, what according to you is the best amendment in CP Act? Which one is your favorite and why?
I would say that the inclusion of e-commerce is one of my favorite in CP Act, because if we see currently, and especially during the COVID times, we have seen that 90% of people have shifted from going to shop in shops to online shopping. This including e-commerce in CP Act has been beneficial for those people as well.
Right, good. Can you please explain your statement? Justice given by court would be less than the cases filed?
Ma'am, because if we see that they have reduced the pecuniary limit, and the cases have increased, the filing of cases have increased, and it leads to burden on courts. Thus, I said that the justice given by courts would be less than the cases which are filed.
Okay, fine. Thank you, beta.
Welcome, ma'am.
Yes, next one.
Thank you. Now, I would like to call Rakshita Shah. Her topic is a comparative study of mediation provisions in relation to consumer protection in India and United Kingdom.
Good afternoon, ma'am. I'm audible, right?
Yes, of course.
Yes, ma'am. Yes. So, as said, my topic for today is a comparative study of mediation provisions in relation to consumer protection in India and the United Kingdom. If I may get a second to share my screen. Just a second, ma'am. I'm really confused how to do that.
It's okay, dear.
Yes, ma'am. Yes.
Yeah, it's
So,
the script is visible.
Yes, ma'am. Yes. So, starting with the introduction, ma'am. Next, please. So, the topics taken are need of mediation and benefit of mediation. So, these points have already been discussed in detail in the previous sessions, and in fact, a very beautiful paper was written on it for mediation provisions in India.
so I'm not digging much into it. But as of now, like the backlogs in the consumer forum is so huge that the very purpose of making it a quasi judicial institution, so faster redressal is kind of defied, and then and thus there is a need for in the legislation. Next, please. Next, please. So the objective of my research is to study the mediation provisions as envisaged under the Consumer Protection Act 2019, the Consumer Protection Mediation Regulation 2020, and the Consumer Protection Rules 2020, and to compare these provisions with the UK legislation, which has two things, that is Consumer Protection Act 2015. It doesn't talk much about the mediation provisions. In fact, they have a very separate regulation, and it's called the Alternative Dispute Resolution for Consumer Disputes, Competent Authorities and Information Regulation 2015. So as such, the comparison is made between the rules, regulations and Act of India and the regulation 2015 of UK. The hypothesis of my yes, the hypothesis of my research holistically, mediation as in the mediation provisions of India. Next. Next. Yes. So ADR provision. So in India, we don't have ADR provision. We have only mediation provision, which are given under Chapter 5 of the Consumer Act, and the sections are Section 74 to 81. And there are many provisions included in that. That how do we refer to it, and how it has to be reported when there is a settlement, and so on. And in UK, we have ADR provision. Like they don't only talk about the mediation, but they holistically take the ADR methods. Then we have approach to the redressal mechanism. When it comes to India, the approach is in such a way that once you have to file a complaint to the respective forum, and then you have to give an application for mediation if you find it appropriate and if you are willing to do. But when it comes to UK, there is no such a requisite to file a complaint in any court or anything. Like you can directly approach the ADR entity that has been recognized by the Secretary of State, which is the competent authority in that case. So any recognized ADR official, the aggrieved party in UK can directly approach to that ADR entity. Then procedure for empanelment. So when it comes to India, the procedure goes like that: a nomination committee will nominate a few mediators, and from that nomination, mediators would be empaneled in the consumer forum. But in case of UK legislation, there is no officer or an ADR entity just has to give his application to the competent authority, and while screening that application, if the authority finds it suitable, he will allow him to become an ADR entity. Then a limited range of applicants. So now who can apply for this? When it comes to India, the range is very much limited, like a retired judge of Supreme Court, retired judge of High Court, and retired member of Consumer Commission, or district or session judge who is retired, of course, or any such a judicial officer or advocate having an experience, particular experience. But as said, when it comes to UK, there is no such limit. Any and every person can apply for it, given they supply all the necessary information that has been asked for. Accountability and checks and balances. So when it comes to India, of course, there is a provision for reporting that the mediator, which is who is empaneled, he has to submit a report like how many cases he has received, how many he has settled, and otherwise, and the fees charged, and the experience and his qualification, and so on. But when it comes to UK
UK legislation, the Secretary of State has to evaluate all this and he has to publish such evaluated report on his website about the shortcomings and the best practices of ADR. Then we have online dispute resolution. Now in India, we don't really have a specific expressed provision for ODR, but in UK they have a provision for ODR. Now we have been suffering in this corona situation, and now we had virtual hearings and everything. So keeping that in mind, also the India, it was very much required that the online platform for resolution itself should have been introduced, but it is yet to be incorporated in our act, whereas in UK it is already there. Cross-border dispute, in cross-border any provision in expressway for cross-border disputes, whereas the UK legislation do talk about disputes that can be domestic and that can be cross borders, and the procedure to be followed in respective cases. Next, please. Conclusion. So yes, my hypothesis stand disproved that if we are aware that the purpose of introducing mediation was like one of the reason was the backlogs of the complaints in the consumer fora. We wanted a speedy judicial mechanism when it comes to consumer complaints. So if we wanted alternative methods, why not go for all the methods of alternative dispute resolution and only mediation? We could have applied arbitration, conciliation, and everything, and it should be open for the complainant or the aggrieved party to resort to either of the methods. Suggestions. First, this I have already discussed that we should have incorporated other methods too. Second, the aggrieved party should have an opportunity to directly approach the ADR official. Now, as said, in India, when it comes to consumer complaint, the person should file a complaint and then they have to give the written consent to go for mediation. However, it is not the case in UK. Like you can directly contact the ADR official on their own. Then we have application for the role. This is also discussed that a very limited range of people are eligible for becoming an empaneled mediator when it comes to India. So what happens is that in the first place, the range is very much limited. Secondly, they should be nominated. So kind of the power is very much centralized in the hands of few. So instead of doing that, like list of people eligible, why not we open it for people at large? Because at the end of the day, we are going, I mean, the nomination cell or the selection committee is going to screen all the applications. So at least we can incorporate this thing that instead of putting up a list of eligible people, we can open it for public at large. ODR, we have seen virtual hearings in Supreme Court, High Court. So the same could have been incorporated in this legislation because it is a very recent one, and we have been suffering of this corona situation since 2 years. So keeping that thing in mind, and other benefits of ODR could be inexpensive infrastructure, expeditious methods of like both the parties would be so comfortable doing that, like they are sitting in a home and they can do that. The very purpose of this legislation was to make these things very easier and not in very conventional method of our justice mechanism. So keeping that thing in mind also, we could have introduced the online dispute resolution and cross-border dispute. As said earlier, we don't really have an express provision, so that provision also should have been included in our current legislation. Thank you.
Thank you, dear. Rakshita, very well presented. Yes, Harshad Bhai, would you like to ask some questions to Rakshita Ben?
Yes. Yes, ma'am. What is the time limit to submit complaint to mediation?
When a complaint is filed, sir, so within 5 days, like the mediation cell, I'm sorry, the mediation, yes, the mediation cell, I'm really sorry, I'm just nervous. Like when a complaint is filed to the forum, if the forum finds it appropriate, they would ask the aggrieved party to go for mediation, and within 5 days they have to give the written consent.
if they are ready to go for it, so they'll give their consent, and within 5 days of that written consent, they have to admit that complaint for mediation.
And the mediator decide the case or only help the parties to communicate?
Yes, sir. Mediator does not really give his verdict or anything. He's a mediator, so he is just going to mediate. He's a middleman. He'll just like push both the parties to come to a solution that is agreeable to both, and what they decide, that would be written down, and a report would be prepared, and that would be submitted to the respective forum where the complaint was filed, and based upon that report, a decree or an order would be passed. So the actual solution offered by mediator is not compelling in any sense to either of the parties.
Means the parties can try to settle the dispute themselves. Is it right?
Yes, because at the end of the day, it is their wish whether they want to go for it or not in the first place. Secondly, if they are not satisfied with what the mediator is offering, they can exit that mediation process at any given point of time, and they can resume their complaint the way it is given in the forum itself. And if they are satisfied, or if they have reached a point of solution on their own, they can tell the mediator, okay, fine, that we are settling on this condition, and that would be reported down by the mediator and submitted to the forum.
And what of dispute resolution? It is with the mediation cell.
Pardon, sir, I couldn't hear you properly.
Dispute resolution forum is
Yes.
attached with the mediation cell or not?
Yes. Sir, mediation cell is, yes, attached to the particular commission.
All the forums like national and central. The only dispute resolution
Yes,
in state level. Okay, ma'am, no more questions.
It is at, yes, district and state both levels.
Yes, sir.
Very good, Rakshita. Very nice. No questions from my side. Next presentation.
Thank you so much, ma'am.
Thank you, Rakshita. Now I would like to call Miss Ankita Shah, and her topic is an insight into the liability of legal professionals under the Consumer Protection Act 2019. Over to you, Ankita.
Miss Ankita Shah. I don't think so. She is with
Anisha,
us.
Ankita is here. Yes.
Yes, ma'am, we call her.
Sorry, ma'am, Ankita's laptop is not working. I am trying in mine. Just give me a minute.
Okay, absolutely fine. No problem at all.
Ankita, you can start verbal presentation till your PPTs are shared.
Ma'am, her mic is also not working.
Akansha, she can start from yours, no?
Yes, ma'am.
Ma'am, can we call the next participant, Miss Suman Jain?
It is for session chair to decide.
Yes. Absolutely fine. No problem. Yes, Miss Suman Jain.
Yes, ma'am. Good
If you're with
afternoon.
us today.
The title for Suman's presentation is E-Revolution in Consumer Law, the development of e-consumerism with e-commerce and the rise of e-filing system in India.
Good.
First of
Yes,
all,
Suman.
yes, ma'am. First of all, good afternoon to everyone, Mrs. Senaz ma'am and Harshit ma'am for giving us the opportunity. And my
Good
topic is e-revolution in consumer law. With the rise of e-consumerism and development of e-commerce, we came up with the e-filing system. So, my PPT, ma'am.
Hiya, please share if possible.
So first of all, I would like to give an introduction about how we evolved into the consumer law from 1986 to from 1986 to we came up with the Consumer Protection Act 2019. First of all, e-commerce gave us the platform of comfort, convenience, and speed shopping everything. But with this, we have also consequences of fraud, scams, etc. With that, our government has developed the new Consumer Protection Act, which is not the updated one, but it's a new Consumer Protection Act 2019. So with e-commerce, we have developed the e-consumerism. E-consumerism means a consumer protection at the e-commerce platform. So with e-commerce, the development, the second development of that is e-consumerism, a consumer protection at the platform of e-commerce. We have given provisions to consumers to protect their rights. And with the development of e-consumerism, we have came up with the e-filing system in India. E-filing system has developed in 7 September 2020, which is named as e-Dakhil. Now a consumer got a platform to file their complaint at e-Dakhil. It has easy and hassle-free platform for consumer to file a complaint. Now, please, ma'am, can I get a PPT on? Hello.
Hina ma'am, can you share her PPT?
Yes, ma'am, we are sharing.
Yeah, thank you, ma'am.
If you WhatsApp me, even I can share Hina from here.
Okay, ma'am. E-Dakhil portal was launched by National Consumer Dispute Redressal Commission on 7 September 2020 for online redressal of consumer grievances. This e-Dakhil or e-filing system was developed in 17 states of India. It is also have been given a platform to many of the states and gram panchayat and village to come up with this e-filing system to make easy and e-filing system. Now the Secretary of Department of Consumer Affairs, Leena Nandan, has gave her statement about the e-filing system is over 13,000. Like it has been like not even a it has been like 1.5 year of e-Dakhil system, and about more than 13,000 cases already been filed under this system. And also the helpline number has been given for the consumers to come up with their complaints. And the procedure of e-filing system is first you record your video about what complaints you have. There's a step given, there's a procedure given in on the side of the e-Dakhil system. So it is easy for consumer to know the procedure and understand. They don't even require advocate or legal advisor to file a complaint. So now about it is sorry, over more than 13,000 cases have been filed, and approximately also 647 companies have joined this consumer helpline. But they also appreciate this system of government.
Now, I'll tell you the data, how many complaints are come up with how many sectors. Like e-commerce, from e-commerce, 22% of complaints have been filed. From telecom, it has been 7.7%. From banking, 8.6%. So with development of new system, there also been developing of new system, new information technology. There also been development of new era, a new redressal system for consumers. Um, now evolution. Okay, now I like to compare. Now I like to compare between the old offline system and online system. First, there is a point called convenience and cost saving. So if convenience differs from differs from person to person. If I will prefer the e-filing system. I'll sit at my home and file a complaint against the fraud has been done to me. And if you ask my father for the same, he'll go to consumer court and file the system because he's not so tech savvy. Now for the cost saving system, not cost saving. So it will be a very cost saving for the online system, and it will be very costly for the offline because they have to go to court. It will be also time consuming for them to go and to know the procedure to file a case. It will be very easy for the online system to file a case. Now, if you file a case, you should know the jurisdiction where it will be filed. So for online system, you should not the knowledge of any district, state, or apex court system, but you can file a case, and the further procedure will be taken by the commission itself. But while you go for offline system, there will be a complex jurisdiction, and you have to follow the procedure with offline system. Now, confidentiality. Now, once you file a case offline, there will be a thing, your things, your papers will be confidential between court and everything. But once you go online, there will be leakage of your data. There will be things that which won't give you confidential. There will be a trace of your data. So on online platform, there will be a confidentiality concern, and on offline, you definitely have your confidentiality. Your data will be secured within the code. Now, inaccessible possibility. Okay, I already have mentioned that people with a tech savvy people with a tech savvy knowledge and with amazing technology knowledge, they can go online and can file e-complaint. But as like my dad, like the people who can't use the information technology in a better way, they can for them this is difficult to access, and even impersonal. So if you go offline system, there will be a personal relation between your party and everything, so there will be a possibility of mediation. But when you go for online, there will be no system for mediation. There will be no settlement, but you go online and definitely there is a complaint between each other, so there is no impersonal thing. But now okay, now offline system has come up with only with the 17 states, but in future there is a planning to come up with all the states, but it has a limited range of to handle the disputes. So currently there are only 17 states including Gujarat. Now these are the comparison between offline and online system. I will like to say the conclusion about this is no matter what, online with the increase in information technology and development, will always be developing our e-filing system. Will come up with the easy method to my other topic and other research is comparison between online e-filing of India between US e-filing. Next slide, please. Next slide, please. Okay. Now, in US, the e-filing system and e-redressal system have came way back. E-commerce was developed in 1991. So they with the FT aggregation for US people, consumer, to protect consumer rights. They've come up with the report filing they have matlab, experience like more than 10 years in e-filing. They also crossed the commission for more than 100 years, and even the procedures for filing complaint in US e-redressal system is very easy, very convenient compared to Indian e-filing system. Okay, now while you're filing a report in US e-filing system, online portal, there will be a video tutorials for you to get it easy, and you will for you there will be a very convenient way to file a case. If you are a total naive person, you don't know anything, but you wanna get the protection for your fraud or scam, so there will be very easy platform for you to get it online. But in India, when you go on a site of e-filing, e-dakhil system, there will be difficulties to know the procedure because there is no tutorial given, but the content is given. So for consumer, it is easy for them to get a to see the tutorial and get the procedure done. Okay, now case categories. In India, they handle every consumer complaint, but in US they have limited range of case. Like they only handle frauds, scams. Sorry, they only handle scams, frauds. But like if you've been cheated in lotteries, there is price, telemarketing, credit, immigration services. They handle these services at their e-redressal platform. Now, standardized and systemization of online portal. In India, it has been like only 1.5 years of development of e-filing system. So with development, it will get into the standardized and systemization. But if you go to the US e-redressal online platform, they have experience of more than 5 years. So they have very standardized and systemization. Even the commissioners who have been a part of their committee, they give the video, they give the knowledge, and also if one complaint regarding the scam has came, they will create awareness, they will create an advertisement for consumers, so they get aware, no one else get affected by the same scams or fraud. So it is very systemized and standardized. Now, handling area country. E-filing system in US it has been handled by every state. In India, currently it is in 70 states, but with development and growing of e-filing system, it will be coming to all over the India. Now, confusion and ambiguity. US redressal system is very easy and easy to understand, but Indian e-filing system is still confused and ambiguity because it will require a tech knowledge when you go to it is at early stage. Definitely e-filing system of India is at early stage, so it has some confusion and ambiguity. For that, it needs time and with development it will get a clarity to file e-filing. Now okay, both the nation I already have mentioned tutorial, and both the nation give the cyber mediation service. That is when you file a complaint in both the nations, when you file a report in US e-filing system, and when you file a complaint in Indian e-filing system, they give a mediation. After getting a confirmation of your complaint, you will get a option of go into a cyber mediation, which they provide a mediator for you to get it settled outside the court. If you don't want to go for the easy procedure, so both the nation have this facility. So my conclusion would be, and suggestion would be, ma'am, next slide please. Okay, now my suggestion to e-filing system of India, that is e-dakhil. If you get a complaint regarding a scams and fraud, it should be creating awareness among the other consumers so they don't get into the trap of scams and fraud. Now, second, tutorial for easy understanding for consumer. Okay, when I get into the e-filing, for me it was very time consuming to file a case because it is very step by step, and it is very lengthy procedure. And for US e-filing system, there is easy tutorials, and tutorials are made for them to get into the procedure. Now, promoting online system. Okay, now while I was doing my research paper, I got to know about this e-dakhil. Just a month ago, I just got to know about e-dakhil while I was researching about this, and I didn't got even a research paper about it. So So I want consumer to promote a e-dakhil system over the consumer, so they get a easy and hassle-free platform to file a complaint about them, and they don't get into the court system and don't get into the mess of court system, and there will be easy for them to file a complaint and get it done within their comfort zone. Now making more okay, I have as I said, systemization and standardization is missing in our Indian e-filing system, so they should come up with this and upgrade. Okay, now that it is in the 17 states of our India, so it should be in all the states and villages, and even gram panch, everyone should promote this e-filing system, so it gets easy. With digital era, we should even come up with this e-filing system to make it easy. So my conclusion will be consumer will always be the king. So for their convenience, there should be a evolution, every evolution with development of digital era and information technology. There should be a revolution every time. So we have come up with e-commerce, e-banking, e-consumerism, and now e-filing. And with the development, will also come with the e-redressal system in India. So that's all for today. Thank you, ma'am. And this is my literature review. I got this revamp from e-consumerism, and this is my reference from where I got the news related to e-dakhil.
Okay, very good. Yes, thank you. Harshad bhai, if you would want to ask the question.
Yes, ma'am. Suman, you mentioned in your title the development of e-consumerism with e-commerce.
Yes, sir.
Okay.
Yes, sir.
Then there are two main factors of the e-commerce: marketing and consumerism. Which one is more effective?
Sir, your voice was missing in. There, which two factors you are asking for? Hello,
marketing
sir?
And consumerism. Which one is more effective in e-commerce platform? Because
Sir,
you already mentioned in your title the development of e-commerce, e-consumerism with e-commerce.
With e-commerce. Okay, sir. We have evolved with the e-commerce platform. Now have we, with e-commerce, consumer needed a protection for their rights. So e-consumerism has developed in 2019. So marketing of e-commerce and if you know the algorithm, if you know the documentary Social Dilemma, how algorithm works and how marketing, when you're using social media, there is a marketing about the things you want to buy. If you have searched about it, there is a marketing which influence consumer to buy things as an online platform. On an online platform. So it's always a marketing of sites which influence consumers to get into the e-commerce platform.
And what is the negative effect of consumerism in e-platform?
Sir, e-consumer is a protection for consumers. So it is always a good positive thing to get their rights protected. Now there is always a negative side of consumerism. So the negative side of consumerism is they are not aware of it, first of all, and if there is a lengthy procedure for the same. If they get into the mediation or something, so their rights always be protected for the same.
Okay, Sunil. Over to you, ma'am.
Hi. You have used the word e-revolution. Can you please explain what is e-revolution according to you?
Ma'am, the E letter I have highlighted because first of all, we have come up with the e-commerce 1991 in all over the world. But in India, first transaction was took place over the book we have, one of the consumer had purchased from Amazon. Then the second come e-banking system. E-banking with e-commerce, they have come up with the e-banking system. Now you can do the transaction in e-commerce. Now after the e-banking, many frauds and scams have come. A consumer have been exploited and their rights hasn't been protected at e-commerce platform. So for that, e-consumerism has come. E-consumerism for the protection of consumers. Now for easy and hassle-free complaints for e-commerce platform, like many frauds and scams have been taken place. So now e-filing system has come. But with e-filing, now e-redressal system has also been given to consumer to get an easy and hassle-free
solutions for their complaints.
Okay, fine. Thank you. Thank you, Suman.
Okay, ma'am.
Very nice. Very nicely presented. Thank you.
Thank you so much, ma'am.
God bless you.
Ma'am, can I call Ankita as she is ready with her
Oh, yeah,
presentation?
definitely.
Over to you, Ankita.
Thank you so much, ma'am. Am I audible, ma'am?
Yes, Peter, you're audible.
Yes, yes.
Okay. Good morning, all of you. My today's topic is an insight into the liability of legal professionals under the Consumer Protection Act 2019. We, the people of India, this beginning lines of preamble of Indian Constitution indicates the ultimate sovereignty of the people of India. We, we all are the people of India who are having the sovereign authority under the Constitution of India. We all are consumer at one point of time or another. And to protect the rights of consumers, United Nations has time to time issued many guidelines to protect our rights. So one of the main which I have got is to encourage high levels of ethical conduct for those engaged in imparting services. Now, as we all are aware about the fact that India is a country which is having a dynamic service sector. Now, where the heterogeneous service sectors has many aspects to cover, the Consumer Protection Act 2019, whether it covers the legal professional service under its act or not, is my main focus. So the objectives of the current study is whether the legal professionals are covered under the Consumer Protection Act 2019 or not, what is the judicial approach in this regard, and how we can expand the horizons of consumer rights of the recipient of legal services. For this topic, I have referred following articles, books, and analyzed several judgments given by the judiciaries. Now, the hypothesis of this study is there is uniformity in the judicial pronouncement related to inclusions of legal services under the Consumer Protection Act 2019. Now, to check the same hypothesis, we can go towards the purview of the definitions that had been given under the Act. Now, we have defined here two definitions, consumer and legal services. Whether the client of legal services who are getting the legal services is included under the definition of the consumer or not, and the legal services that we are providing are covered under the services under the Consumer Protection Act 2019 or not. Now, before moving towards solving these questions, we should look into the nature and duties that the legal profession possesses. As we all belong to the legal profession, we are quite aware about its nature. So, unlike other professionals, we are supposed to forward our duties towards courts, towards the society, towards clients as well. And we have to justify all of them. And if we are having deficiencies in providing the same, we are held liable for the same. Now, certain judicial pronouncements in this regard have been made. So the first case I have mentioned here is Srimati versus Union of India. In this case, the question was whether the client is considered under the definition of consumer or not. Now, to show the same, they have mentioned that and taken the wider interpretation of the definition consumer. They have mentioned that the consumer, any services which is given for a consideration and which is obtained for a consideration is considered under the services unless and until it is expressly prohibited or expressly excluded from the definition of the services under the Act. Hence, it was proven in the case that the client is included in the definition of consumer. Now, majorly, we will discuss here two more cases, D.K. Gandhi versus M. Mathias case and Nandlal Loharia versus Jagdish Chand Purohit's case. In the first case, that is D.K. Gandhi versus M. Mathias case, it is quite interesting case that this D.K. Gandhi moved towards the court for moved to the court for holding liable to his advocate, which has in the district court, and in the district court the judgment was given that the advocate was liable for deficiency of services. Now again the case came into the Delhi State Consumer Commission. In the Delhi State Consumer Commission, the judgment was reversed, and the reversal was due to the judgment in the same case was due to the pressure made by the Delhi Council of Advocates towards the court regarding this matter. And again the case came forward to the National Commission. National Commission has well defined the issue, and it gave two guidelines that in the cases where the advocates are not responsible for the favorable outcomes of the judgments, but when it comes to the point that he is actually negligent, then in these cases we are supposed to hold them liable under the case. Now then the same case was forwarded to the Supreme Court of India, and the Supreme Court put a stay on the case, and that stay that had been put years ago, which is not removed till date. Now another case that came forward is Nandlal Loharia versus Jagdish Chand Purohit. In this case, what happened is the same issue ke advocate ke the person came against his advocate and filed a case in the district forum. The complaint was dismissed by the district forum on the basis of the merits of the case. The same judgment was passed by state and national level Consumer Redressal Commission also, and the special leave petition was filed in the Supreme Court of India. Now in Supreme Court of India, they gave the judgment that if any deficiency in services is found, there may be some case, but losing a case on merit and no negligence on the part of advocate will not prove to the deficiency in the services. See, now currently the issue relating to including the legal services or liability of legal professionals under the Consumer Protection Act was raised by our parliament also. The point was Parliament was willing to include the legal services into the definition of the Consumer Protection Act and in the definition of consumer as well as in the definition of services. Then the Bar Council of Delhi has raised an issue against it, and we can see the same in the letter drafted here, in response to which Shri Ram Vilas Paswan had to say that मैं स्पष्ट करना चाहता हूं कि कंज्यूमर प्रोटेक्शन एक्ट 2019 के तहत बन रहे रूल्स में लीगल सर्विसेज को शामिल करने का कोई प्रस्ताव नहीं है। साथ ही कंज्यूमर प्रोटेक्शन एक्ट 2019 में वर्णित सर्विसेज की परिभाषा में संशोधन का भी कोई प्रस्ताव नहीं है। To give such clarification by Shri Ram Vilas Paswan made it quite clear that even though we are well aware that the legal services are also a service which a consumer comes across in his daily life, though we are not able to give them clear rights in this regard. Now, on the basis of these facts, judgments, and all such, the null hypothesis is hereby rejected. Recommendations in this regard are: we must give some clarification in this regard, and we all need to unite together, and we need to formulate certain principles to govern the matter, so as we can I conclude hereby that we must keep in mind that even a single step in right direction matters. We might not be able to solve the issue overnight, but once we have recognized the issue, we must at least try to solve the same. Just avoiding the issue and be a silent spectator is of no use. Thank you.
Thank you, Vita. Yes, Harshad bhai, if you would like to ask some questions.
Uh, only one question I want to ask.
Yes, sir.
Ma'am, that the matter of negligency by the lawyers, he could be charged with under the CP Act or not?
Judicial pronouncements are having differential opinions in this regard. Whether they are covered under the Consumer Protection Act or not, in different judgments they have given different opinions. As we have seen the judgment given in the DK Gandhi's case, the district forum has said that they are held liable for the negligency under the Consumer Protection Act. They are covered. And even in the case where the question was came that medical negligency is also covered under the act. So the question also raised at that point of time, if doctors are covered under the act, why advocates are given special treatment or special immunity under the act? So in this case, the stay was put by the Supreme Court and it is not removed till date. But the another judgment that we have recently received in the Nandlal Loharia versus Jagdishan Purohit case, it was held by the Supreme Court. Though the judgment was that this special leave petition, the judgment given by the Supreme Court was that the case was dismissed on the basis of merits. If the case is dismissed on the basis of merits, then the advocate is not held liable. But if actual negligency regarding case or regarding the duties towards his client is proven by the same, then we are liable for it.
And legal professional are not liable under the CP Act. Is it true?
No, we cannot actually state that the legal professionals are not actually liable under the act, as it is not specifically it is not excluded from the definition of services.
Okay, okay, ma'am. Say that.
Okay, fine. So is it educational institute are not under the CP Act? Ankita? Ankita Ben?
Yes, ma'am.
Educational institute are not under the purview of consumer? Or students are not under the purview of consumer, is it so?
No, ma'am. It is not clearly mentioned.
Okay, fine, fine. Thank you, thank you. Done with. Next.
Now I would like to call Dr. Meera Sharma, and her topic for presentation is price control and consumer protection. Meera ma'am.
Hello, am I audible?
Yes, ma'am.
Yes.
Good afternoon, one and all. And I would first of all, before I start with my presentation, I would like to thank Dr. Iramala and her team for giving me this opportunity to present this area of interest to such elite people in law. Who have such expert knowledge in front of me. Still, this small effort of mine I'm going to present right now. So I will present this presentation now. Right. Hello team, I'm not able to share my presentation from my laptop. Can you please share it, share the same? I'll guide you.
Yes, ma'am. Yes, we will share.
Meera ma'am, you begin with introduction. Someone will help you.
Okay, okay, fine. Hello. Am I audible? Hello.
Ah, yes, yes, yes.
Huh.
Yes, Meera.
So,
Very
my area of interest, which I'm going to present over here, is I'm still working on it actually. It is the price control mechanisms with respect to the consumer protection. And before we, of course, a lot of knowledge has been imparted in these 2 days, on Saturday and today, regarding Consumer Protection Act. But with regard to my presentation, I would again stress on the section 2, which clearly emphasizes on the price control of the Consumer Protection Act 1986, and which includes the right to be informed about the quality, quantity. Okay, now I think the presentation is also getting projected. So, right to be informed about the quality, quantity, potency, purity, standard, and price of goods, products, or services, as the case may be. I'm glad in the previous previous presentation, the services were also highlighted by Ankita, which I'm also stressing over here. Along with the products, it's the services also which have to be assured to the customer. And then the restrictive in the section subsection 41 of section 2, there is restrictive trade practice, which is to prevent the unfair trade practices. Means a trade practice which tends to bring about manipulation of price or its conditions of delivery, or to affect the flow of supplies in the market relating to goods or services in such a manner as to impose on the consumers unjustified costs or restrictions, shall include delay beyond the, it is with respect to the type of service of the supply of the goods also, which is being covered in this. Next please. And the next is the consumer protection rules. The previous one please. 1987 and the consumer protection regulations 2005 deals with the basic rights of the consumers, that is the right to safety, right to be informed about quality, potency, and purity of products, the right to have access to variety of goods of competitive prices, rights to redress grievances, and the right to consumer education. So these are the basic rights which are being handled by the consumer protection rules. So next please. Hello. Huh. So this is in line, the first part of this slide is in line with what Suman just now presented regarding the preamble of the Indian Constitution. And it has been really a very nice revelation when I am pursuing LLB right now. And when I read through the Indian Constitution and its implications in various laws is really, really interesting. I am completely amazed by the protection which we all civilians and the, of course, military personnel, every consumer is also having with respect to our ever evolving and emerging law and the rules. This Article 38 of Indian Constitution is particularly implicating the protection which consumer enjoys. The state shall secure a social order for the promotion of people's welfare and shall effectively work to achieve a social order in which justice, economical, and political shall inform all the institutions of the national life. So this people's welfare is the crux of the consumer protection. So this is the guiding law for the Consumer Protection Act also. And as Dr. Vikram Desai in the morning mentioned about the law of torts, which I find very complicated personally. And of course, it is based on judicial cases. In this, the particular case which, the first case which formed the basis of consumer protection in law of torts is Donegal and Stevenson, which laid out the principle that the manufacturer owes a duty of care to every possible consumer of his product, and that such a consumer can bring an action against the manufacturer even if there is no contract between both parties. I think this is a guiding line for having quality control, QC department in almost all the industries. It is the guiding line, and QC department forms the heart of any industrial organization. Next, please. There are various regulations, not just Consumer Protection Act, as has been um, also illustrated by so many dignitaries in the law in these 2 days. There is not just one Consumer Protection Act which is giving protection to consumers. There are various other regulatory guidelines which are giving protection to consumers, and these are the Sales of Goods Act in 1930. I'm going to briefly go through these. Of course, it is very much in the knowledge of all the participants and the experts in this field. Still, I'm just going to brush up. The Sales of Goods Act 1930, in this section 16 of this act deals with the implied conditions as to quality or fitness. Bureau of Industrial Standards, sorry for the misspell, it emphasizes on the formulate of the standards expeditiously, review of the standards, technological developments, and the harmonization of the standards, domestic standards with the international standards for facilitating international trade. Next, please. Next, please. Next slide, please. And then is Prevention of Food Adulteration Act 1954 to ensure food to be pure, nutritious, and free from any type of adulteration for proper maintenance of human health. Standards of Weights and Measures Act 1976. Essential Commodities Act 1955 to control the supply and prices of the commodities mentioned in the act. It may regulate or prohibit the price, production, or distribution as per the need of the hour. Next, please. Now, particularly of my interest is the price control during the COVID pandemic in India. This case, which I am mentioning over here, is with respect to the medical devices costing. It is the Delhi High Court judgment with respect to Rare Metabolics Life Sciences Private Limited and others versus Matrix Labs. There, the High Court slashed the price of the medical diagnostic kit from 400 to 400 from 600, which was being available at that time. Because in such a case, the judges, they took into account the losses which the industry was experiencing, and the consumer was putting so much, was put on to so much of stress because of the loss in business. And so to give a relief to the consumer, this slash of price was done. Previous slide, please. So this is with respect to the medical diagnostic kit pricing, but at the same time, I would also like to mention over here the ambiguity in the law with respect to the new patented drug prices. It has been brought to there has been a judgment by Delhi High Court last year in February 2020, where they exempted the new patented drugs from price control, which I find is, that is my hypothesis, whether it is justified or not. I'm still working on this, gathering more evidence and the judgments on this case. Because in US, if we go, there is a price cap which is put for the new patented drugs. And whereas in India, this kind of law is lacking, so that the customer is, or the consumer is exposed to exorbitant prices with respect to the newly patented drugs. On the other side, it is a discouragement for the new R&D for industry to develop new drugs and patent the same, because they should also have the incentive to patent new drugs, to bring them to the market, to undergo clinical trials, and to have the value for the R&D and the time and the money which they spend. So it is a double-edged sword. So we have to still, there is a lot of work which needs to be done on this regard as far as the exemptions from price control are concerned. So I'm still working on this paper, and I shall definitely do more research on this, and I would really welcome the suggestions from the chair of this session. And so now next is the effectiveness. The conclusion of this particular presentation is the effectiveness of various laws which have been put forth for consumer protection depend on two variables. One is the alertness of the consumers, and the second is the sincerity of the authorities in their implementation of the laws which have been laid forth. So for presently, I end my presentation, and I would really welcome the suggestions and the comments from the chair. Thank you so much.
Thank you, Dr. Meera. It was indeed very nice presentation on a very nice topic. Harshad bhai, if you would like to ask question.
Yes, ma'am. Ma'am, operation research is one of the method that we can add as a one of the factor for the price control management.
Sorry, sir, the question is not very clear to me. Can you please elaborate on it?
Yes, ma'am. Operation research method.
Yes, sir.
It is the method that is used for profit maximize.
Right.
Yes, so we can add as a one of the factor for the price control management.
Yes, 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 definitely. It is one of the variables. Actually, that is the reasoning which industries they put forth, that why should we spend so much of time and money into R&D if we are going to be limited by the price, because ultimately every industry goes for looks for the profit. That is how the knowledge economy works. So in such a case, of course, that is one of the variables and one of the limiting factors also. So that is why I said that this drug price control mechanisms are double-edged sword. On one side, we have to look into, the lawmakers have to look into the interests of the industry so that the R&D does not suffer. And on the second hand, interests of the consumers also have to be looked into so that they also are not put into excessive financial burden. And so taking both these things side by side is very difficult, I understand, and that is why I'm still working on it, trying to find more judgments all over globe to give some more clarity on this, so that this, if this research paper of mine gives some more clarity to various lawmakers, and it will be really nice. I'll feel fulfilled in my research work in this topic. Hello, sir.
Over to you, ma'am.
Thank you. Thank you, Dr. Meera. It was indeed very enlightening presentation. I think Miss Anisha Sahuwala is ready.
Yes.
Presentation already indeed.
Thank you for your patient listening too, ma'am. Yes. And Dr. Harshad also, and all the participants too. Thank you so much.
Thank you. Nice meeting you virtually.
Yes.
Now I would like to welcome Miss Anisha Shahuwala, and her topic for presentation is consumer as drivers of corporate social responsibility. Over to you, Anisha, ma'am.
Good afternoon, everyone.
Good afternoon.
The title of my paper is Consumer as Driver of Corporate Social Responsibility. I can start from the words by telling that if your customers don't trust you, you don't have customers. Going to the introduction part, in the world of CSR, three P's are important: people, planet, and profit. That is to operate in an economically, socially, and environmentally sustainable manner. One of the most important and emerging drivers of CSR are the consumers, who play an integral role in determining a company's CSR policy. Nowadays, consumers care a lot about issues of corporate social responsibility, and this can influence their behavior as consumer and potentially therefore influence the companies from which they buy to be more responsible towards social and environmental issues. Moving to the review of literature, the first thing, the father of CSR, who called Howard Bowen, he, in his book Social Responsibilities of the Businessman, defined CSR. He defined CSR as the obligation of businessmen to pursue those policies, to make those decisions, or to follow those lines of action which are desirable in terms of objectives and values of our society. R.G. Carroll, who has given the pyramid 4 levels of corporate responsibility, he also given the 4 pillars: economic responsibility, legal responsibility, ethical responsibility, and with the philanthropic responsibility. Also, I referred some journals, articles with for my topic. Going to the research methodology part, the present study is based on secondary data. The required information has been derived from various books, articles from journals and magazines, and from the various websites. The limitation of the study is based on published data and information available on internet. No primary data is being collected. The objectives of my studies to study the relation between consumer and corporate social responsibility. Second one, the objective of this to investigate that CSR would positively influence the benefit and the value perceived by the consumer, green environment or consumer purchase decision in market. To analyze the consumer as drivers who are pushing business towards CSR. The hypothesis of this research paper is consumers purchase the goods and services which are ethically responsible. That is, there is an impact of CSR activities of the company on consumer purchase decisions in market. And the second hypothesis of this paper is the consumers are the real drivers of CSR. Moving to the CSR and consumer. The responsibility of company under CSR to the consumers are that they have to offer the fair pricing to the consumers. They have to offer the quality product. They also have to offer the sale service, after sale service. That is, after sale also they have to offer the service which they need. No unfair trade practices are allowed, and also they have to be contribute to the social change. The main theme of the research papers that consumer expects better business practices and will pay for it. A report at Economic Times, which is published under the title Majority Indians Now Purchase Items Based on Social Responsibility, Inclusiveness and Environmental Impact. This data is published by Capgemini Research Institute. This was last updated on August 1, 2020 and accessed by me on February 26, 2022. The source is also mentioned in the slide. They are telling that the data is that 79% of consumers are changing their purchase preference based on social responsibility or environmental impact. Due to COVID-19 crisis, 65% are more mindful about the impact of their overall consumption. 52% of consumers share an emotional connection with products or organizations they perceive as sustainable. 53% of consumers overall and 57% in the age group of 18 to 24 has switched to lesser known brands because they were sustainable. And the last 64% said that buying sustainable products made them feel happy about their purchases. This data is of India. Going to the data of USA, which is published in the Green Print Survey, finds consumers want to buy eco-friendly products but don't know how to identify them. The source is mentioned in the present slide. This was published on 22 March 2021 and accessed on February 26, 2022. The article said that the first ever edition of the company's business of sustainability index found that nearly 2/3, that is 64% of Americans are willing to pay more for sustainable products. 74% even don't know how to identify them. And 78% of people are more likely to purchase a product that is clearly labeled as environmental friendly. The Unilever study, which is based on the London, UK data, this also published on 5th January 2017 and accessed on 26 February 2022. The source is mentioned in the present slide. They are telling that a study by Unilever reveals that a third of consumers, that is 33%, are choosing to buy from brands they believe are doing social or environmental goods, which data is 53% for UK, 78% for US, 88% for India, and Brazil and Turkey are sharing 85% that they feel better when they buy products that are sustainable. We all know about the Nestle commitment, good food, good life for consumers. We all even know about the PNG products, that every time you choose a PNG product, a part of the profits go towards educating underprivileged children. That is, all brands are including in the PNG fixture so that consumer can attract and also contribute to the welfare of the society. The analysis and finding of this research paper is based on the hypothesis. The hypothesis one was an impact of CSR activities of the company on consumer purchase decision. The finding of this research highlights that there is a positive influence of purchase intention and consumer trust developed by socially responsible firms on the actual buying behavior. That is, the first hypothesis is proved. The second hypothesis, including objective one of my research paper, that is relation between consumer and CSR. The market polls recommend that there is a positive relationship exists between company CSR activities and consumer relations to that company and its products. The result shows that consumers are an important potential driver of CSR. So this, I can say the second hypothesis is also proved. Going to the conclusion, very proudly I can say that India is the first country who has been made CSR mandatory by law under Section 135 of the Companies Act 2013. With this, when business are environmental friendly, support social movements, and provide positive working conditions, then evidence suggests that this improve profitability and encourage outside investment. Being a good corporate entity is the need of the day. For sustainable development, in the long run, those organizations or group of persons who do not exercise power in a way which society considers will tend to lose success and dignity. Well said line returned by the father of our nation, Mahatma Gandhi. A customer is the most important visitor on our premises. He is not dependent on us. We are dependent on him. He is not an interruption in our work. He is the purpose of it. He is not an outsider in our business. He is part of it. We are not doing him a favor by serving him. He is doing us a favor by giving us an opportunity to do so. With this, I will conclude my research paper by giving some recommendations. Awareness about CSR in consumer is a need. Consumer education is required to increase and support the CSR activities. Government can play a major role in educating the consumers by implementing various policies that can have transparent policies of CSR activities conducted by any corporate, and the government organizations should promote various schemes to motivate people to understand the need and importance behind CSR activities. Some references are mentioned, the internet websites, the access given also, that when the access was done. And with this, thank you to everyone.
Thank you, Anisha Ben. Very well presented. Can you please elaborate the point that you have suggested lastly? Okay, consumer education is required to increase and support CSR activities. Could you please explain it? Anisha Ben?
Anisha, are you there?
Yes, ma'am.
Kindly answer question.
Yes, ma'am.
Anisha, could you please elaborate the point that you have suggested that consumer education is required to increase and support CRS activity? How consumer education supports CRS activity? CSR, sorry.
Actually, if we see most of the consumers which is a part of the society, they don't know what is CSR. If we say the word corporate social responsibility, they don't know what is corporate social responsibility. If I will say the consumer doesn't know about the corporate social responsibility, how they can contribute in that or achieve the government, or we can say the India team, we can do some CSR activities. So of course, consumer education, that what is CSR, government has to do some awareness program about the CSR, making them know what is the company duty towards the CSR and how they have mandated under the Companies Act 2013 which they have to do and what benefits they can give.
Okay, fine. Yes, Dr. Rawal, sir.
No, ma'am. No, ma'am.
Okay, fine.
Thank you.
સેશન
Shall we
છે
start,
તમે
madam?
તમારા ઇનપુટ્સ આપો તમારા ઇનપુટ્સ આ સેશન.
Yes, madam.
Shall I
Good
start,
afternoon,
Rashid?
one and all. First of all, let me say congratulations to you, ma'am, and Team VTC for organizing such a wonderful event. I think about 30 papers have been presented in the last 2 days. And it is a matter of great pride that everyone has performed with a great interest. Congratulations to all presenters for actively participation and made this event grand success. Actually, ma'am, I also wanted to present paper, but could not submit on time due to exam and other reasons.
હર્ષદભાઈ તમે
હા,
કેસ કમેન્ટ કે બુક રિવ્યુ કઈ લખીને મને મોકલાવો એડિટેડ બુક થોડા દિવસ રહીને પબ્લિશમાં જશે હું પબ્લિશ કરીશ આઈ પ્રોમિસ ટુ પબ્લિશ ઓકે પેપર
Okay, ma'am. Okay, ma'am.
બીજા કોઈ કેટેગરીમાં આઈ પ્રોમિસ ટુ પબ્લિશ.
Yes, ma'am. Finally, I thankful to Irmala ma'am for giving me the opportunity. Thank you. Thank you so much, ma'am.
વેલકમ. શનાઝબેન.
Yes, good afternoon to one and all present here. Indeed, the session was very enriching and very nice. Came to know about the various aspects of Consumer Protection Act and various avenues and arenas in which one can work. All the presenters were very good. Indeed, I have asked questions to all of them and marked accordingly. Now let's see who gets the best paper award from the student section or from this category. Once again, wish you all very best of future. And I would like to congratulate and thank Dr. Irmala Madam for organizing such a fruitful and a nice conference, a virtual conference on such an important topic in this present scenario. Thank you all. Thank you.
હર્ષદભાઈ, શનાઝબેન, થેન્ક્સ ટુ બોથ ઓફ યુ. આટલા બધા પેપર્સ પ્રેઝન્ટ થયા, તમે કેટલું પેશન્ટલી બધાને સાંભળ્યા ને મેન્ટલી ને ફિઝિકલી પ્રેઝન્ટ રહ્યા વર્ચ્યુઅલ કોન્ફરન્સમાં. થેન્ક યુ.
A pleasure to be amongst you all and be amongst all our presenters.
Okay.
Mirabai,
vote of thanks. Vote of thanks પછી આપણે વેલિડિક્ટરીમાં પણ તમે પ્લીઝ 5 મિનિટ હાજર રહેજો પછી we'll end up the count.
Yes.
Yes. Who is proposing vote of thanks today?
Yes, ma'am. Now I would like to call Ajay sir to propose the vote of thanks.
Thank you, Hina ma'am. A lovely and warm afternoon to our most valued and holy guest, management committee, respected teachers and beloved participants. Thank you is such a word that cannot be seen or touched. It must be felt by heart. It's a matter of pride for me that I am proposing a vote of thanks for this distinguished conference. On behalf of my colleagues and the entire committee, I want to thank our chief guest, Honorable Justice Sri Mahendra Parikh sir, Honorable Justice Sri Vasu Kumar Patel sir, Sri Rajesh Desai sir, Professor Sri Percy sir, Advocate Sri Sukumar Pats Joshi sir, Chairman of Administrative Committee, Advocate Sri Shreyas Desai sir, who gave their vital time from his busy schedule to agree this meeting. I want to thank all the speakers, Dr. Vikram Desai sir, Dr. Jetri Desai sir, Dr. Manisha Shukla ma'am, Dr. Sehnaz Bilimoria ma'am, for gracing us with the detailed learning sessions. We are truly grateful to have your associate with our college. Further, a big thank to the session chair of technical session, Dr. Sehnaz Bilimoria ma'am, Dr. Harshad Rawal sir, and Dr. Bhadresh Dalal sir for their effort toward today's anchoring with their appreciating ideas. I mention my sincere sense of gratitude to them. I would like to place my hearty thank to all the volunteers and participants because of whom made this conference possible. I also want to thank all the teachers for their cooperation in the college conference. We are fortunate to dedicate and well motivate them our college who are aware of their task and are very confident about the result. I would like to thank all the respected representatives who have blessed us with their presence. We have been fortunate to be assisted by our principal in charge, Dr. Irmala Dayal ma'am. You have been a constant support and give us lot of encouragement. Thank you, ma'am. A special thank to conference convener Miss Anisa Sahuwala for the planning, organizing, and executing this virtual conference. I would like to thank all organized team, teachers, and staff members. Last but not least, I thank all our students for showing their interest in the program and making this program a huge success. Thank you. Thank you all.
Thank you, Adisa.
Okay, thank you. Who is taking over?
Uh,
I think
Anisha
Anisha ma'am
ma'am.
is taking over. She was in my cabin. She'll join us soon. Before
Okay.
we move further, as soon as we receive some details, we will be announcing the best paper in the teachers category as well as students category, two best papers rather. And before concluding, we will like some feedback from some of our participants also. Anisha ma'am will shortly take over and move further.
So we can start, ma'am. With this, we come to an end of the day 2 of the second virtual National Conference on Expanding Horizons of Consumer Rights. It has truly been an enriching experience. We now commence our valedictory function, which is not, you can say, incomplete without the feedback. So for that, I will call Dr. Fainaz ma'am to share her opinions for our conference.
Hi, yeah, thank you. I'm very much with you all. As I already said in previous sessions, a very big congratulations to Dr. Irmala Dayal madam and her team for organizing such a fruitful virtual conference. And we hope and we wish for furthermore conferences on various topics in the coming times also. I would like to congratulate each and every participant who has presented the paper. Presenting paper, making a research paper is indeed a very tough job. I know that. And as we all have hectic schedules and as we all are running short of time, to complete a paper in a prescribed time itself is a big thing. So a very big congratulations to all of you. I would also like to thank my guru, Dr. Vikram Desai sir, Dr. J.T. Desai sir, Dr. Kamlesh sir, Advocate Kamlesh sir, Shreyas sir, and all, as it was a very nice opportunity to listen them to all and to be a student all over again. And I would like to thank VT Choksi Sarvajanik College for organizing and giving us an opportunity to be a part of this wonderful virtual conferences. And thank you all. It was very nice being with you all for these 2 days. I felt like I was sitting with you all and I was interacting. Though I'm in my office, I felt that intimacy and that hospitality from your side. Thank you all. Thank you.
Thank you, ma'am. Now I will call Dr. Bhaumik Upadhyay sir to share his feedback. Bhaumik sir, I think he is not there. I request Ms. Hemal Patel madam to share her feedback.
Hello everyone, it is my pleasure to become a part of this conference. I would like to say that I am very glad to receive valuable knowledge from well-experienced judges, advocates, my teachers, my principal madam, and other dignitaries all together at one platform virtually. And I suppose to that the modern generation of law field in India is actual need of gathering versatile knowledge of law through this kind of program, so that it is likely to be conducted this kind of conference every year. Thanks a lot, giving a great opportunity to all of you. Thanks again. Bye.
Thank you, ma'am. I request Dr. Tasneem Patel, madam, to share her feedback.
Good afternoon, everyone. It's been a wonderful experience attending this two-day national conference on consumer protection and the expanding horizons on consumer rights. It's been extremely enriching, informative, listening to all the speakers as well as participating. So it's been a wholesome experience. And Dr. Dayal, as usual, is always on a commendable, she does a great work and she takes everything so passionately, and that kind of comes to all of us. So I wish everyone the best of luck, and I just hope that the college does many more such conferences in the near future. Thank you.
Thank you, ma'am. I request Dr. Meera Sarma, madam, to share her feedback.
Good afternoon, one and all, once again. It was truly an enriching learning experience for me as far as this conference is concerned, and I was truly in awe of all the speakers, especially the main dignitaries who are expert in their field, and they took out time to indulge upon various aspects of consumer protection. And of course, my interest in law is increasing day by day, and that Ramla ma'am already knows how interested I am now in all the various intriguing aspects of law. And thank you very much, Dr. Ramla ma'am and the team, for organizing this conference and letting me be part of it.
Thank you, madam. I will now request Ms. Ushma, madam, to share her feedback.
Very good afternoon to all. It was indeed a matter of pleasure and a best opportunity to be a part of this conference and to write the research paper and present it in the conference. I learned a lot from each and every participant. And the resource person, my gurus, Manisha madam, Shahnaz madam, J.D. Desai sir, Vikram Desai sir, and great thanks to Dr. Nirmala ma'am. She always motivated and guided me to work better and better in the area of research. And as it is a knowledge gaining conference, I would just like to add one thing. There is a change in the pecuniary jurisdiction of the commission, and by the central government notified Consumer Protection Jurisdiction of District Commission, State Commission, National Commission Rules 2021. According to this notification, the pecuniary limit of the State Commission, of the District Commission, is reduced to 50 lakhs, and State Commission from 50 lakhs to 2 crores, and National Commission about 2 crores. I think it was already in the initial session by senior advocate, and even Mahendra Parikh sir also stated this. I would just like to add on this and draw attention to all the participants as well to this change in the pecuniary jurisdiction by this notification. That's all. It was really a good and experience to be the part of this conference. Thanks a lot to all. Thanks a lot.
Thank you, madam. I request Dr. Sunny Hassani sir to share his feedback.
Yes, good afternoon to all of you, and it was really a nice experience to be part of this second virtual national conference. Last year also, when this conference was organized by VT Choksi Law College, I was the part of this conference in the both ways, being a presenter also and being the session chair also. This time too, Dayal madam gave me an opportunity to be on this platform. So I must congratulate all of the organizing team members of VT Choksi Law College, their consumer club. Special congratulations to Dayal madam, who has taken this such an what I should say bold initiative to organize second time the conference on the same topic. Friends, it is not like this that whatever legislation is passed by the government, once it is passed, it is over. In fact, when any new legislation comes, the actually the burden with the people like us is more to create awareness about that law, that legislation, so that more and more people should know what the law is about. Dayal madam, again, once again, hearty congratulations to you for successfully organizing this virtual international conference. Soon proceedings will be also what I should say released by the team. I hope so. And in future also, I would like to get engaged with this reputed institution working for welfare of people. So yes, with this, all the participants with the organizing team, to the principal, once again congratulations and thanks a lot for making part of this conference. Thank you.
Thank you, Sunny sir, for always supporting us in all our academic endeavors. Thank you.
Thank you, sir, for your support. I request Advocate Forum Madam to share her feedback.
Good afternoon to all my mentors, and very firstly, I am very thankful to Irmala ma'am to push beyond my boundaries. And one another thing that for the very first time I have participated in which was very wonderful for me. And once again, thank you so much, Irmala ma'am. It was a very good and wonderful experience, and I am like moving forward and pushing forward myself for putting more and more research paper in very different subjects and aspects regarding the legislature in India. Thank you.
Thank you, Forum Madam, for your kind words.
Thank you, Madam. I request Ms. Suman Jain to share her feedback.
Yes, sure, ma'am. First of all, I would like to thank Irmala ma'am. She gave me this opportunity. She's always been my law guru. She's always inspiring and idol to me. Like somewhere I always see herself that I'll be there someday. She's always inspiring. Any speech of her, she's remarkable. She's commendable, amazing. And also she gave this opportunity to me, to other students to come up with the research paper. Then all the conference judges, Shanaz ma'am, Harshad sir, who have been given amazing time to us, and also all the research paper members who have gave their knowledge about consumer law. There's so much more to know, so much more to learn. So thank you so much to everyone who have contributed to this. This is very learning thing about everyone, about everything. So thank you so much. Looking forward to more such things in the law field. Thank you so much.
Thank you. I request Ms. Ruhi Bhatia to share her feedback. I think Ruhi is not with us. Dr. Bhaumik Upadhyay, are you there? I think sir is not there. Ma'am, we can conclude it.
Manisha ma'am has joined us. Ma'am, will you please sum up at the end?
Yes, sure, my privilege. Yes, it was a really nice 2 days virtual webinar. And I would really say that the new act which has come, so everybody must know this act perfectly. And so all those participants have taken really due care to complete the whole part of, that is, I can say, from 1986 history to 2019 and what will be the effect of the act. And every subject has given due importance overall in consumers, because the starting of this particular session which was been done by the two justices and the leading advocates. They have tried to focus on consumerism, the definition, the history part, and with that, what were the lacunas in 1986 and what has been covered up under 2019. So the students have got the complete impact about 2019 very well. Thereafter, nearly 33 papers, as you have said, were presented, and all of them have taken due care and diligence to perform it in a perfect way. Yes, some of the internet issues which we see here and there are okay with, but that we have to bear with. But that is acceptable, and we have learned to overcome all these things. Even presently, I got into this program twice, and I was been thrown out by the net. So there are somewhere or the other net issues always with us, but still with all that lacunas also, we have tried to sum up this particular seminar webinar with the perfection, and the credit goes completely to Irmala ma'am and her team, all those who are working hard, maybe since last month or more than at that time, because this needs a pre-preparation, designing of that, how we are going to move on with this, and then again calling all the luminaries, legal luminaries for that. So all that needs lot of patience, working with them, internet, because earlier what used to that, when webinar was that, people were officially coming to our colleges, we used to have nice time with all that. But now only on virtual meet we are trying to be engaged with each other, and this is one of the best I can say program of this starting of the year has been done by VT Choksi Law College. So I'm really happy with Irmala ma'am, the management was really very supportive with you, ma'am. I can really tell you that management always comes in your program. So that credit you have built up with them, that is really good. And you could actually tell all your professors, motivate them to present the paper also. So that was also a plus point of yours. Very nice of you. Even all those professors who have actually presented their papers, done well, very well. And thanks again for inviting me also in this second virtual seminar. I was also part of the first one, and now the second one, and hope next year we are going to see it the third time. Maybe with the same subject or the new subject, whatever you call for. So we would be happy to join you anytime. So thanks for all that, whatever things you have done for this webinar. And thanks to all the participants as well, that they have done the work very nicely. Thank you so much, Irmala ma'am.
મેમ તમારા વગર હું નહીં, એકે લો કોલેજના એકે ટીચર કોઈ પ્રોગ્રામ નહીં કરે VNSU સાથે. That I know very well. Your support I am counting and relying on. કે મનીષા મેમ તો
You must.
And
I'll
all
be
the
always
teachers also supported.
always there.
Thank you, madam.
Thank you, ma'am.
આપણે
I request Dr. Yeah, ma'am. I request Dr. Irmala Dayal, madam, to announce the best paper award.
એક મિનિટ અનિશા મેમ, એક ટેકનિકલ ઇવેલ્યુએશન શીટ હમણાં જ હાથમાં આવી છે. We will go through it and give me 1 minute's time and I will announce.
No issue, ma'am. We can wait for it. Even lots of participants are waiting for that.
મારું કેમ દેખાતું નથી? હા, ફાઇન. સૌથી પહેલા તો we announce the best paper in students category. Teachers can wait for a while. It is shared amongst 3 of our students. The 3 students the organizing committee have finalized. They are Suman Jain, Meera Sharma, and Heta Desai. Heta has presented a paper on e-commerce and consumer protection. Meera Sharma has presented a paper on price control and consumer protection. And Suman has done good job on e-revolution in consumer law. So you 3 will have to share this paper. Congratulations to all 3 of you.
Thank you so much.
Thanks a lot, welcome, dear.
We
Thank
have
you,
made this
Heta.
just because of you and VD Toxi College. Thank you, ma'am.
We
Yes,
all are
ma'am. Thanks
together.
to you
Even you
and
are
credit to you for
No,
all the
most welcome.
support. Thank you so much.
Thank you, thank you. And
Thank you,
now, even the actually, Shana, we have wiped off 5 papers because we did not find them frankly up to the mark and did not have patience to wait for them to do corrections. So only I think 27 papers have been presented. We had got registration for 32, but only 27 were presented. An organizing committee has again finalized 3 authors in the best paper presentation in teachers category. And the list is in my hand now. First, Shanaz Madam, Nikun Sir, and Rakshita Madam. Dr. Shanaz Balimoria's topic was e-commerce and consumer protection, analyzing the legal regulations. Congratulations, Madam. All teachers are becoming your fan, it seems. Mr. Nikunj Rathod, consumer protection and e-commerce, rules, implementations, and challenges. And Shanaz Madam recommended Rakshita Ma'am. She gave her very good marks. So she is also sharing the same paper with you, Shanaz, same award with you, Shanaz Madam. A comparative study of mediation provisions in relation to consumer protection in India and UK. I hope we have been fair. And if there was any lacuna in the execution of the conference, my regrets. I have a very young and enthusiastic team, and they always try to deliver their best. Our management is pro-teachers, pro-institution, always supporting us in all our endeavors. In fact, for 2 days, when technical staff is on the premises, if anything goes wrong. So that is the extent to which they go to give their support to us in our academic endeavors. Shanaz ma'am, congrats once again.
Thank you, ma'am. Thank you.
Shanaz ma'am, congratulations.
Thank you. Very sweet of you. Thank you.
એક વીકમાં સર્ટિફિકેટ ને બધું પહોંચતું કરો છો. ઓકે મનીષા મેમ, આ કોન્ફરન્સના ઇમ્પ્રુવમેન્ટ માટે કોઈ ટિપ્સ હોય તો કાઇન્ડલી લેટ મી નો. I will try to make some changes in the future programs.
No, see, conference was always very nice and nicely performed. Only to this participants, I would like to see that, the papers were really good. Only thing was that time management has to be taken care of. And the second thing is, there is a marks for questionnaire, but so many times it happens that we don't get the chance to question the students because the time goes very fast here. So due to that, some of the students may have got less marks or maybe not up to the marks. Otherwise, papers were really good. Okay.
Thank you. With this note, Anisha ma'am, can we end now? She's the conference convener.
Thank you, ma'am.
Okay.
With this, thank you, Manisha madam. Thank you, Fanal ma'am.
Just a minute. Anisha ma'am, Ketna ma'am is joined right now because of examination duty. She could not join beforehand. Ketna, can you please share your feedback if you are up to it? I think I saw Ketna's message right now.
Good afternoon, ma'am. Good afternoon. First of all, I'd like to congratulations Nirmala madam as well as entire VT Choksi College for organizing such a beautiful event. I'm feeling very much happy to given such a precious opportunity to become a part of this wonderful virtual webinar. Even we are inspired to organize such a beautiful webinar just like this. So it's a really, ma'am, nice, and congratulations to all of you, ma'am. And paper presentation was also very nice. Congratulations once again, ma'am.
થેન્ક યુ કેતનાબેન. ચાલો મનીષા મેમ, શેનાઝબેન ને બધા ડિગ્નિટરીઝ આ નોટ પર આપણે હવે કોન્ફરન્સ ફિનિશ કરીએ. બધાને ભૂખ પણ લાગી હશે. ઇટ્સ લંચ ટાઈમ. થેન્ક યુ.
Thank you everyone for your participation. One information is there that the feedback link is shared in the chat box. Please fill the feedback form for the certificate. Thank you. And we hope we will meet again to the next webinar or seminar or conference, whatever the Dr. Nirmala Dayal madam will arrange, and we will be a part of it. Thank you, ma'am.
No more conference for one more year. After that, we'll think no more conference.
Thank you, ma'am. Thank you.
Thank you, ma'am. Thank you so much.